Hi everyone. My name is Donna Lyons. I'm with the Trinity College Dublin School of Law. I'm really honoured to be speaking with so many leading scholars today. So this is a follow-up to a conference that we held on the 15th of July this year on COVID-19 public international law. We have some of the same speakers back to speak to us today: Benedict Kingsbury, Juan Mendes, and unfortunately Ayel Benvenisti wasn't able to make it today due to circumstances outside of his control, but he is with us in spirit today and he sends his best wishes. Today we will be talking about a variety of issues, again relating to COVID-19 and public international law, including human rights and health, the right to liberty and prisoners during the pandemic, social movements in COVID-19, challenges facing the EU during a time of crisis, and derogations from international human rights treaties. And this is just some of the very interesting topics that are arising today. In terms of the format, each speaker will have 15 minutes to present, and I will introduce the speakers as we go along. And then at the end, there'll be an opportunity for Q&A. So if any of the attendees have any questions, feel free to put them into the text box at the bottom of the screen there, and we'll address them towards the end. We also have a panel of students who have been very supportive in helping us to organise and to promote this event, and they'll be involved in the Q&A as well. So I'd just like to say I'm really grateful to all of those students who are here today. And on the thank yous, really grateful to the law school, very grateful to Trinity Research in the Social Sciences, who've been very supportive in organising this with us, in particular to Maeve McGrath and Donna Lyons of TRIS. In particular, I'd like to thank the speakers, really esteemed panelists today. It's really an honour to be speaking with you, to hear your insights on these current and pressing issues. And with that, I won't take up any more of your time and I will kick it off. So to begin, we have Professor Laurence Helfer, who circulated a draft article in advance. And Laurence will speak about derogations from human rights treaties in the context of the COVID-19 pandemic. So Professor Laurence Helfer is Harry Orr Chadwick Senior Professor of Law at Duke University Law School. And following Laurence's presentation, Amina Adanan from Maynooth will present a reply to the paper. And we will have an opportunity at the end of the various presentations for Sue replies if that's something you'd be interested in. Okay, so I would hand it over to you then, Laurence.
Great, can everybody hear me? Yeah. Okay, great. So first, thank you to Donna and to the organizers for keeping our scholarly activities going during this difficult time. It's a real pleasure to be with all of you virtually, if not in person. So my paper focuses in on the question of rethinking the system of derogations from international human rights agreements. And it's prompted in part by some of the recent developments with respect to COVID-19 and how states have responded to it. It's also prompted, though, by my work on human rights and other treaty flexibility mechanisms, including exit clauses, escape clauses, flexibility mechanisms, and so forth. So it provided an opportunity for me to revisit some of the earlier work that I've done, empirical and theoretical work on the purpose and function of derogations, how they're operating in this particular crisis, and then what that might lead us to think about in terms of reforming the system of derogations. Now, I should say that this idea of reforming the system or critiques of the system is hardly new. It's been going on now for some 30, 35 years. But I think it's reached a rather acute point, and I think it's also quite acute because of the moment that we're in with respect to the international human rights system, with respect to both reviews that are ongoing within the United Nations, the treaty body strengthening exercise, regional mechanisms reassessing their roles, and states reassessing whether and how much they want to defend the system as opposed to maybe disengage from it in whole or in part. So the basic idea here, I'm sure I don't have to tell all of you who are here, you know what human rights treaty derogations are. The grounding for them in the three of the leading civil and political rights agreements is that states facing crises of various sorts have this kind of inevitable tension between, on the one hand, trying to respond to exigent circumstances, which might include, for some period of time, limiting rights. And on the other, the concern that emergencies are kind of the sine qua non of human rights abuses, in the sense that they provide opportunities for majority governments to consolidate power, to restrict the rights and liberties of disadvantaged groups, of political dissidents, and so forth. So the drafters of the treaties try to kind of square that circle, if you will, by providing a safety valve within these civil and political rights agreements, allowing for temporary suspensions during times of crisis, but setting up a mechanism for limiting those suspensions and for putting in place a system for international review and monitoring. So part of what the paper does is go through why it is that states would go ahead and derogate. And building on some of the previous work that I've done with Emily Hafner-Burton and Chris Farris, two political scientists who do a lot of writing on human rights law and institutions, we take the position that essentially derogations provide a mechanism for states to that are interested in being participants in the system to buy time and breathing space from interest groups, from voters, from legislatures, from courts, to signal that right suspensions, even if they're unpopular, are necessary, temporary, and subject to justification. And by doing that, by putting their views publicly out there, and by putting out their justifications and also a time period within which rights restrictions will last, they're putting their credibility on the line, and they're providing information to a variety of different non-state actors, and in some cases perhaps to other states, to be able to hold them to account if those suspensions are not followed or the restrictions on them are not followed in practice. So that's the idea. And in some sense, the COVID derogations are highly positive or favorable from the perspective of international human rights law. So for example, one scholar, Alan Green in the UK, has called them the kind of the ideal state for derogations. Why is that? Well, the pandemic is not, the United States, perhaps one side, a political development. It is a public health development. It affects everyone in many different national jurisdictions. And it does so in quite similar ways. And so it's not surprising that we actually have more derogations from the ICCPR, the American Convention, and the European Human Rights Convention in response to COVID than we have had in response to any of the other sorts of crises or exigency situations. So terrorism being the most recent obvious one, but not by no means the only one. And so from that perspective, it seems like derogations would be a natural response. And in fact, most of the right suspensions relate to freedom of movement, freedom of assembly, and other kinds of rights that are specifically linked to things like lockdowns and restrictions that are designed to prevent the spread of the pandemic. So that's the good news. The less positive news is that far, far more governments are enacting emergency measures in response to COVID-19 to restrict individual liberties than are derogating. So, and I cite in one of the footnotes in the paper, I think it's footnote 20, there are many, many websites that are doing a phenomenal job of gathering very fine-grained detailed information about precisely which rights restrictions are being put in place, by what mechanisms, and with what effect. And so what we're seeing is that the derogating countries are really the tip of the iceberg, right? They are, some of them are following the rules quite closely, but others are not following them at all. And some seem that are similarly situated are behaving very differently. So countries that are neighbors with each other, one will be scrupulous about derogating and modifying derogations, and now we even see some terminations of the suspensions of rights, while another will do nothing. So that's a problem. Other problems, I think, that the COVID situation has exposed with respect to derogations concern the fact that there is no real linkage between the the procedures and mechanisms within domestic law for adopting emergency measures that limit rights and freedoms, and the international derogation system. So as I explained in the paper, when governments derogate, usually executive branch officials are making this decision, they're focused in on the immediate crisis. They're worried about what voters will think, they're worried about what legislatures will do, they're perhaps worried about judicial review. Probably the last thing on their mind is whether they need to derogate or not. And in fact, I think it's kind of remarkable. I kind of turn a statement by the Special Rapporteur on Terrorism and Human Rights on its head. She says, well, it's kind of surprising. It's a puzzle why states are not making greater use of this justificatory mechanism in international law. My puzzle is the opposite. Why are they doing it at all? Why do I say that? Well, because there isn't a kind of built-in incentive in most countries. There are a couple of exceptions, and I was able to find one exception where there actually is a built-in obligation to derogate in domestic emergency legislation. But that's one concern with the system. The other concern with the system is when states actually do participate. So they don't participate enough, even when they should. When they do participate, the timing and content of their notices are very often deficient. So they're late, and they're insufficiently justified in terms of explaining their necessity, their proportionality. Why is an emergency rights suspension necessary in a particular circumstance? Now, I will say that COVID derogations have been much better in this regard than have responses to previous emergencies. And we see more citations to national laws, we see more references to domestic decrees, we see more information about specific time limits, and that's obviously very positive. On the other hand, it's also quite true that we see most of these notices tracking whatever restrictions or notification requirements exist in domestic law. In other words, states are not fully informed about what their obligations are under the treaties they have ratified. And so what they're tending to do is saying, oh, well, we just realized we have to derogate, we should derogate. So let's just take what we already put in some other document and let's send it to a treaty depository. The third big problem that is been true for some time is the delay in reviewing these notifications. So they come into treaty depositories, as you all know, and more or less treaty depositories view them as kind of more or less a box checking exercise. Did you derogate? Did you provide us with the relevant information? Yes, you did. Okay, our job is now to post it on, the relevant website and to circulate it to the relevant officials and other states parties. And so the actual review on the merits may not occur for years, and it may not occur at all if there is no mechanism for challenging it under an individual complaints mechanism, or if it kind of gets, by the time a state files its periodic report to the UN Human Rights Committee, there are other problems that it's encountering. So there may not be meaningful review, and I've found some situations where there's been no review at all. That's problematic. So I also identify three broader trends that I think are exacerbating the incentives to not participate in the derogations regime and the incentives of states when they do participate to do so ineffectively. So first of all, there's a little notice provision within a lot of these clauses about which links them to other international agreements, other international law, both customary and treaty-based. And I found that to be particularly interesting because the overwhelming majority of treaties that have been adopted and widely ratified since the mid-1960s lack derogation clauses of any sort. There are a few exceptions, and I note them, but with the exception of the three that I discuss in detail in the paper, those few that have derogations clauses, they're never used, as far as I can tell. If somebody knows to the contrary, please let me know, since I still can work on the paper. And they seem to, from one perspective, actually be expanding the rights and freedoms in that they allow for international review and monitoring and limit state discretion, but without this derogation provision. But I think there's a problem in that all of the existing derogation clauses contain this indirect linkage mechanism. Now, no tribunal, no court or treaty body, to my knowledge, has ever said, oh, you can't derogate or your derogation is invalid because you are not adhering to your obligations under another treaty. But you can see how this could play out in principle and in practice. So if you think you are going to try to say derogate as the example I give in the paper, derogations with respect to the ability of police to respond to domestic violence, put aside whether that's plausible or not, under what circumstances or not, but whatever you may do there, you're not going to be able to get out from under your obligations under CEDAW. So from one perspective, if you're really taking the law seriously and paying attention to it, you may not actually be able to derogate at all in that area. Now, is that good or bad? That's a separate question, but it certainly constrains states' freedom of action. The other developments relate to the expansion of rights, in particular, the expansion of non-derogable rights by the Human Rights Committee, the ECHR, and the Inter-American Court. And I detail in the paper precisely how these are expanding, in particular in the area of economic and social rights, but also with respect to the right to life and positive obligations relating to torture and CID treatment. So the upshot is here that states have a much, much larger set of obligations that are non-derogable without any concomitant increase in their ability to exercise this safety valve. So in the final part of the paper, I propose a number of different reforms along 5 different dimensions. Embeddedness, engagement, information, timing, and scope. I won't go through all of them because I think some of them are too detailed in the interest of time. But I do think one of the key things that is quite important is to be able to put the derogations obligation to somehow embed it in a domestic legal system, to somehow trigger that mechanism, because the ability to have scrutiny and oversight is surely important, right? There's a reason that litigants go to the Human Rights Committee and to the regional human rights tribunals to challenge derogations. But part of what the function of derogations is informational and putting certain boundaries through the disclosure of restrictions that the treaties require in their derogation clauses. So if you're not even thinking about derogations, you're not even part of that conversation about limiting discretion to restrict rights. So that's one important thing. The other would be to build a little bit on a mechanism within the Council of Europe, which was proposed and then not really acted on, to have treaty depositories be more proactive when they get notices of derogation. They're the first line of review or defense, if you will. Now you have to be careful here because, of course, they can't usurp the role of the tribunals in reviewing the substance. But they could do a variety of things, such as assemble best practices, disclose information about what other states are doing, engage in informal dialogue with states to say, do you really need to derogate? Why are you derogating? What other information could you provide to us? So I go through a whole series of what I hope are very practical reforms. And I also, and I'll close on this point, the other thing I do is I try to identify these as being, in terms of how they could be implemented, as ranging along a spectrum. So some can be done voluntarily by individual states acting under their own domestic authority. Others would require some degree of collective action, whether by states or by international experts like the Venice Commission or treaty depositories, to come up with a set of guidelines and best practices that states would that would be publicized and promoted and hopefully adhered to. We really don't have, we have, of course, older statements like the Syracuse principles and others, but they really need to be updated and they could be really much more precise. And we could learn from the experience of the COVID derogations in that respect. And finally, and I don't advocate this, but most specific, potentially controversially or most expansively, if there are going to be systemic reforms, whether that's through the treaty strengthening process or in the Inter-American system or in the Council of Europe, which has been adopting a variety of different protocols and reviewing the performance and caseload of the ECHR, if there are going to be institutional reforms, reforming the derogation system could be embedded within that. And what I would hope to see would be a mechanism whereby states are incentivized to participate in the system, where their decisions are subject to disclosure and constraint in a meaningful, time-sensitive way, in such a way that whatever necessary suspensions of rights they put in place are time-limited and proportionate. Thanks very much. I'll stop there and I'll mute myself because I'm eager to hear Amina's comments.
Thank you so much, Professor Helfer. I found your paper extremely interesting, and I have a couple of comments that I'll bring in at the end, but I'm going to ask Amina to provide her expertise before we move on. And just to note, before I introduce Amina, that Alan Green actually spoke at the previous conference on the 15th of July, so I think he'll be very interested in watching the recording of this. So I'm delighted to welcome Amina Adanan, who's a lecturer at Maynooth University Department of Law here in Ireland, and has significant expertise in the areas of international human rights law, public international law, international criminal law, amongst other areas. So really honoured to have you here today, Amina, if you would like to go ahead.
Of course. So hello, everybody. Good afternoon. Thank you very much to Donna Lyons for the opportunity to contribute to the conversation today. So as Donna's outlined, I'm going to respond to Professor Helfer's excellent paper. So first of all, I'd like to thank Professor Helfer for the brief presentation and for access to the paper, which is excellent. I thought that the paper does a great job of critiquing the derogation regime in international human rights law, and in addition to that, in making proposals for reform. I think now is definitely the time to rethink the rules that suspend human rights during emergencies, and that is timely and essential, to borrow some of Professor Helfer's words. So my contribution here today stems from issues that came to mind while I read the paper, and also some areas where I thought might be fruitful for further development. So that's what I'm going to focus on for this presentation. So in particular, one statement that really resonated with me in the paper was the fact that rather than using the derogation regime, many states during the current pandemic have instead opted for more internal mechanisms, such as introducing emergency measures and exceptional measures. And I find that very interesting. So most of my presentation, or most of my response, centers around trying to answer that question and explore that a bit further. So Professor Helfer notes that 30 states derogated from human rights treaties during the pandemic, while 100 states opted instead to enact emergency measures. Of course, the move away from the derogation regime towards introducing emergency measures can be viewed as a progressive development in international law, which is one of the views that Professor Helfer outlines in his paper. However, the critic in me is not so convinced. And ultimately, I think it might be too soon to provide an in-depth and definitive answer to that question. But for now, I'm going to share just my hypotheses on potential answers for that question. So the first heading I'm going to explore in attempting to answer this question is under the title of whether this development is further evidence of the move away from multilateralism that is currently underway in international law, sadly. So the variety of measures taken by states to respond to the pandemic may be symptomatic of the move away from multilateralism that was already evident prior to the pandemic. The rising nationalism and the increase in self-preservation measures that has already been seen in member states of international and regional organisations have indeed been further exacerbated by the pandemic. One recent example being the withdrawal of the US from the World Health Organization. This move away from the collective goals of institutionalism is evidenced in this part of the world by failure of the member states of the European Union, the most integrated regional organisation in the world, to orchestrate a unified response to the pandemic. One such example of the failure of the European Union to act in a multilateral and cohesive manner being the unilateral suspension of freedom of movement of European Union citizens within the EU as state borders were closed. Within the current international landscape, it may be the case that the move away from derogations towards emergency measures and exceptional measures is indicative of states relying on self-preservation rather than on international institutionalism. The post-war international setting has changed, and it was within this setting that the current international legal framework was created. The number of states that are participating in international institutions has significantly increased, and the post-war power balance that existed between states during the creation of the international legal regime is no more. What is worrying is the increasing lack of willingness of states to engage with the expansion of international human rights, infrastructure, and instead to rely on domestic systems, which are often not as protective of human rights as in the same way as the international system protects those same rights. And I'll explore that a bit more in my next heading. States are moving away from international human rights infrastructure, and at this juncture, it is worth giving as an example the recent decision of Benin and Côte d'Ivoire to withdraw from the protocol to the African Charter on Human and People's Rights, which allows NGOs and individuals to make petitions to the African Court of Human and People's Rights. In the European context, a further example is the increasing restrictions that are being placed on NGOs and individuals operating in EU member states who promote human rights. And this was detailed in a recent European Union Fundamental Rights Agency report that was entitled "The Challenges Facing Civil Society Organisations Working on Human Rights in the European Union." There is no doubt there is a trend that states are adopting unilateral measures and procedures over those set by international institutions, which leads me to my next point, which explores the domestic setting in which international law operates. So Professor Helfer asserts that one reason why states may not derogate under an international treaty is the fear of having the measure challenged in a domestic court, and no doubt that is the case. The section on consequences for states' incentive to derogate assumes that states incorporate human rights treaties into domestic law, and that derogations can be challenged on that basis in the national legal system. I agree with Professor Helfer's proposal on embedding derogations in national domestic law, and I think that's really needed. But I think that both of these points assume that states are incorporating international law into their national legal system, which unfortunately is not always the case, particularly in relation to common law dualist countries such as Ireland, which require the incorporation of international human rights treaties into domestic law in order to be relied on in court. So in this jurisdiction, in the Irish jurisdiction, the ICCPR and ICESCR have not been incorporated into domestic law. Of course, some civil and political rights that exist in the ICCPR can be found in Irish domestic law, principally in the Irish Constitution, or Bunreacht na hÉireann of 1936, which predates the ICCPR. So some example of civil and political rights that can be found in the Irish Constitution that are also in the ICCPR are fair trial rights and freedom of assembly and the right to liberty, which are expressly provided for in the Basic Law. Sadly, the parity of economic, social and cultural rights in the Irish Constitution makes it extremely difficult to enforce rights of a socio-economic nature against the state through the likes of judicial review. The word derogation does not appear in the Irish Constitution. However, there are a number of fundamental rights that are qualified. So prime examples of these, a prime example would be the freedom of assembly, which can be qualified on the grounds of public order or morality. In most common law jurisdictions, in the event of a conflict between the highest source of domestic law, principally the Constitution, and international law, the Constitution will prevail. To take the Irish jurisdiction as an example, the European Convention on Human Rights has been incorporated into Irish domestic law on a sub-constitutional level in the ECHR Act 2003. So this means where a measure is challenged on the basis of a right's existence in the ECHR or in the Constitution, that the courts are more likely, if they can't find a solution, they will lean first and foremost to the Constitution, as opposed to the expansive scope of the right in the ECHR. And this position is not unique to Ireland. It can be seen in other common law dual estates. And so for this reason, I see the proposal of embedding derogations in international treaties in the domestic legal setting as problematic, particularly in states where international law is incorporated on a sub-constitutional level. So my third and final heading relates to the origins of derogations in international law and international human rights treaties. So in contemplating the question as to why most states did not derogate from human rights treaties and instead opted for more internal measures, I also note that most, as Professor Helfer addressed in his presentation, that many contemporary human rights treaties don't include a derogation clause. And I find this very, very interesting. In his article, Professor Helfer notes that Article 11 of the Convention on the Rights of Persons with Disabilities affirms that all states parties must take all necessary measures to ensure the protection and safety of persons with disabilities in situations of risk, including situations of armed conflict, humanitarian emergencies, and the occurrence of natural disasters. In addition to that, Article 4 of the CRPD specifically prohibits derogations from the states parties' obligations in the treaties. Similarly, no derogations can be found in the Convention on Enforced Disappearances and in the UN Convention Against Torture. This is, I think, is a really interesting development in the historical trajectory of human rights treaties. As someone who spent a lot of time researching the travaux préparatoires of human rights of treaties in the 20th century, I wonder, is this part of a wider? Does it indicate the fact that there is a change in the number of states and the power balance between states who are creating these treaties? And I'll come back to that in a moment. So the research of Professor Helfer and others notes that there's three main human rights treaties that provide for derogations: the European Convention on Human Rights, the ICCPR, and the American Convention on Human Rights. So I thought it would be interesting to look to particularly the ECHR and the ICCPR and see, well, where did the proposals for derogations during the negotiations come from? So the travaux préparatoires of the ICCPR and the ECHR demonstrate that the two treaties were being drafted, well, the ECHR and the treaty that later became the ICCPR demonstrate that the two proposals overlapped, or the proposals for each treaty overlapped. And you can see this in the travaux préparatoires of each treaty. The research of scholars such as the late A.B. Brian Simpson in his book Human Rights and the End of Empire, and the work of my colleague here in Maynooth, John Reynolds, in his book Empire, Emergency and International Law, illustrate the colonial underpinnings of derogation clauses in human rights treaties, specifically the ICCPR and the ECHR. The research of these scholars and others demonstrates that the idea of derogating from human rights commitments during emergency originates from British proposals to include such provisions in the treaties, and that those proposals were dependent on successful lobbying to have those proposals incorporated into the finished draft of the treaties. So these proposals were based on self-interest, as these scholars note, and Reynolds gives the example of at the time that Britain was involved in drafting the ECHR, it had introduced emergency measures in some of its colonies at the time. Reynolds also notes that during the drafting of the ICCPR, the US and French proposals for a draft convention did not actually include proposals for provisions for derogations in those treaties. Derogations are inherently linked to the idea of the legal concept of the legal construct of a state of emergency, as states of emergency were an inherent element of the colonial conquest that allowed for heinous breaches of fundamental human rights. To return to modern times, one could justify the lack of a derogation clause in recent human rights treaties on the grounds of the large number of participating states, particularly those from the global south, and how, with these voices being included in modern international treaty negotiations, it is one reason why it is no longer the case where a handful of dominant states from the global north dominate the treaty negotiations, and as such the result is different. However, it should be noted that many of the states that did include emergency measures during the pandemic are obviously part of the global south as well. So I'm going to leave it there for now. I look forward to any comments and questions on this presentation, and I look forward to discussion thereafter. Thank you very much.
Thank you so much, Amina, for those really insightful comments and thoughts into Professor Helfer's paper. Thanks for taking the time to read it so carefully, and it'll be really interesting to come back to this discussion towards the end, so thanks again. So delighted now to introduce Professor Alicia Yamin, who's a senior fellow at the Petrie-Flom Center for Health Law and Policy, Biotechnology and Bioethics at Harvard Law School. Alicia will talk about COVID as an inflection point, revealing increasingly intrusive global neoliberal economic governance and limitations in our theorization of health rights. And I will hand it over to you, Alicia. Thank you.
Thank you very much, Donna. I'm really honored and delighted to participate in this panel. I'm going to try to share my PowerPoint slides now with everyone. Can everybody see that? So this is actually, my career has focused on health rights, health and development, and particularly economic and social rights. So it's going to be quite a different style and possibly tone of talk than you've just heard, both of which I really, really enjoyed. So here you see the ranking of global pandemic preparedness that was just prepared before COVID-19, with the USA at the top. And unless you believe what the current occupant of the White House says, we have not been doing such a tremendous job in our response. So the question I'm starting with is sort of the narrative around this pandemic. And there are overlapping narratives. One was it's the great equalizer, and that happily has fallen aside because it's clearly not the great equalizer. One was that it's the great disruptor, that previously we had been marching along progressively in both global health and human rights largely. And this is a disruption in the possibilities of achieving the Sustainable Development Goals, for example, a disruption in our economy, but as soon as we get the vaccine, we'll bounce back. In another narrative is that it's the great revealer, that it has shown us all of a sudden, for example, in the United States, oh, we have unfinished racial injustice to address and things like those kinds of inequalities. And that has led to, you know, build back better. That's the diagnosis leads to that. And my narrative is going to be kind of none of those. It's that we have known for quite a while in economic and social rights and other, and certainly in health rights, in the intersections of health and human rights, that we have been on the wrong path. And it has now in this pandemic become so acute and such a cause of moral distress to see the scandalous inequalities, not just in health, not just in racial injustice, but in so many different domains, that we can no longer turn away. So it's really an inflection point, not just for global health or for economic policy, but also I think for thinking about international human rights law and certainly economic and social rights. So my starting points are that health patterns of health and ill health are really keen reflections of justice and injustice, whether it's because you're a displaced indigenous person or a woman or some other marginalized population or just poor. That health is not as, and you know, many of these things seem so obvious now in light of the pandemic, but I have been saying them for years and years and years, and people are like, you know, the idea that COVID is not some stochastic phenomenon, that it is not about the pathophysiology of this virus. Although some people still say, oh, well, there's more COVID in these populations because they have preconditions, et cetera. And health is not just related to narrow individual behaviors as we tend to think in public health about, of course we should all be wearing masks, I want to be very clear on that, but the structural relations, the way the housing conditions we have, the food security, the employment security, is much more actually important to who gets this disease and what the outcomes are. The second starting point is that health systems, again, this seems so obvious now, but really for years it has not been, that health systems are not a matter of kind of religious charity, which historically they've been organized by religious institutions, and they are not marketplaces. They're not insurance markets, which is largely the way they are run in the United States as well as some other countries. They are really core social institutions. So in human rights, we're very, very used to looking at the prison system or the criminal justice system or the electoral system as institutions that can silence and exclude and punish certain populations. But health systems actually do exactly the same thing, and we don't often look at them that way. And I would have said pre-pandemic that women, because of their reproductive intentions and capacities and their caregiving roles, bear the burden of this kind of exclusion from society through health systems. But now it's a much broader phenomenon. And I also, a third big starting point is that we are seeing now the accumulated effects of decades of neoliberal legality, institutions, and governance. And I'll give you just two tiny examples of how that plays out. So we all know by now, it's practically a mantra, you know, we should test, trace, isolate. That's, you know, the public health mantra. Well, if, you know, clearly we have not done a good job on testing in the United States, but that isolate part is really, really important. And you can't just tell people, okay, so go isolate. They need to have a safe space to isolate to. They need to know that they will be getting food when they isolate. They need to know that their children will be taken care of, that they won't lose their jobs. So in a country where there's not a social protection or social safety net, where we don't have that, that public health mantra immediately crumbles and falls apart. So how did we get here? Why didn't, after I've been in this field, and it's a self-criticism, working on economic and social rights for 30 years. So how did we get here? And I think part of how we got here is, you know, the questions we have asked in human rights. So we tend to ask, who's kept low on the social lever? Who's excluded from society by discrimination? Who's not treated as a full member of the polity? And we've also, in economic and social rights in particular, focused on poverty, and I would say especially extreme poverty, as a enormous human rights issue. But those questions lead you to look at disparities, racial disparities in lots and lots and across the board in health, as well as housing and life expectancy and income, etc. But, and by the way, it's not just the it's not just the United States. But they don't lead you to look at the social gradient, at inequality. And that we're going to come back to, because it's not just a matter of economic and social rights and human rights, but it's also a matter of democracy. Again, it's not just in the United States. We've seen this absolutely across the world. By 2015, Oxfam was reporting that the top 1% of the world's population had as much wealth as all the rest. So why did we ask these questions? So I am going to take as a starting point for this brief whirlwind historical tour Sam Moyn's point that it was, you know, this is the ascendancy of human rights really began in the 1970s. In the Cold War, civil and political rights abuses in dictatorships had really been focused on by the West, by the United States. And in decolonization, we had seen that those countries that were proposing a new international economic order were not always democratic, right? So there were terrible dictatorships and abuses, also interests of the Western countries, and human rights largely became split off from macroeconomic development. Human rights was concerned with this dyad of the individual versus the state, and macroeconomic development was international. And in democracies like the United States, you know, we had theoretically post-civil rights, but it's not really post-civil rights, and this is not a Trump rally. This is actually from the early 70s. We had women's liberation. It wasn't until the mid-1970s that all women could sit on juries in this country. We had Roe v. Wade, of course, and a lot of backlash. So it was really about, it was a time of greater class equality, of relative growth, and of high tax brackets, so above 70% in the United States, through the 1970s and higher previously. And it was about these other populations getting a right to participate in society. So I'm going to sort of fast forward and condense, because all of you know, of course, at the 1980s, everything changed with Reagan and Thatcher, and structural adjustment, which really had horrible consequences across the global South and the poor in the global South. And structural adjustment is often talked about policies, but that required legal change. That was really the ushering in of major neoliberal legality and of law and economics thinking, where the private sector, I know this is a lecture series on public international law, but private law was encased and sealed off from public law. But nonetheless, in those decades, we were still thinking in human rights that the Convention on the Elimination of Discrimination Against Women came into effect. Then the Convention on the Rights of the Child combined child survival and development with the idea of the rights of the child. The 1990s was a decade of really aspirational, transsectoral conferences that linked human development concepts with human dignity and human rights. And we had, over these last 30 years, an absolute proliferation of human rights, special procedures, norms, institutions. And we were really focused on all of that and making that work. And there was social transformative constitutionalism, probably most visibly in South Africa on HIV/AIDS, where you had the Prevention of Mother-to-Child Transmission case, you had a Pharmaceutical Manufacturers Association case, and Hazel Tao and other cases. In Latin America also, you had HIV/AIDS drugs, in India as well. So that really started the idea that health rights were real legal rights and could be enforced, and that the human rights community could make changes that in global institutions as well as national institutions and national policy. But that was all happening against a backdrop of continuingly stringent structural adjustment, trade liberalization that was zealously imposed upon all countries wanting to be part of a global trading system, financial deregulation and increasing financialization at the end of the 90s and into the 2000s, changes in antitrust law that have brought us some of the large digital corporations that we have today. And it was also created a different kind of governance that I think is profoundly technocratizing and de-democratizing, in that structural adjustment could be measured through indicators from the World Bank and from the IMF. And that's how the Millennium Development Goals and now the Sustainable Development Goals are largely monitored. And I'm not going to spend time on that, but I'm happy to talk about what that means for holding your own government accountable and human rights. So the last 10 to 15 years in health rights is often considered to be the era of operationalization, that back to that narrative of this is a disruptor. The era of implementation, we had, health rights have come of age, we have legal enforcement in many, many, many countries, even in very poor countries. We recently had a judgment from Uganda on enforcing the right to maternal health, which I was involved in. The proliferation, I would say, somewhat fragmented interpretations of what health rights mean by treaty monitoring bodies. We had the beginnings of human rights-based approaches to health, the idea that how to translate legal norms into policies, which is not self-explanatory in health, which has many multivalent implications. And so the beginnings of human rights-based approaches that were subject to intergovernmental review at the Human Rights Council, for example, started in health. And that started in 2012 and has proliferated. But again, this is happening against a backdrop of enormous economic volatility, the 2008 financial crisis, the food crisis, changes in laws, and I want to point to this again. In the United States, we have the Citizens United case, and all of a sudden you have billionaires and corporations literally drafting legislation on tobacco and alcohol and sugary beverages in many countries around the world, which obviously is an enormous political determinant of health. And you also have the same kind of starvation of resources at national level happens at global level. So there's more philanthrocapitalism, there's more corporate involvement in global governance. And you can see from this chart, which is maternal newborn child health, tracking the money and what it's given to, that it would really be inordinately difficult to establish lines of accountability, either for financial commitments or for outcomes in these cases. So that was all producing enormous, not only enormous inequality, but this is one of the keys. All of these, the financial deregulation, the antitrust, the illicit financial transfers, are producing, it's not that money has shrunk, it's that the amount of money we have in the public fisc to spend on economic and social rights, to spend on health systems and social protection systems and pension benefits has dramatically shrunk, while private capital has increased. And that means that states are starved for resources, and it's a vicious cycle, because this concentration of wealth and power in private hands leads to manipulation of the political system as well. You can see here that Jeff Bezos, who's only one I could point to, but has made tens of billions of dollars, 55 billions of dollars just since this pandemic has begun, while millions, the estimate is that millions, tens of millions, are going to be thrust into extreme poverty, and millions will probably be on the verge of starvation. So I want to conclude on a bit of an optimistic note, remarkably, since that seemed sort of grim. The first is something that a very dear colleague who passed away recently and has been an extraordinary colleague, friend, and mentor, Sally Mary, who wrote initially about this theme of vernacularization of human rights, like to say there's human rights officialdom, capital H, capital R, and then there's human rights, the story about what it means to be human, to have dignity in all of our diversity and equality. And I think that human rights with a capital H and capital R is at a perilous place right now, but we have never needed human rights, the lowercase story, the story that animates people in the Green Wave in Argentina to come out to the streets, the story that animates the protesters against racial injustice in this country to come out to the streets in this pandemic, the story that animates the people who will come out to the streets in Chile, even in the midst of a pandemic, to vote for a plebiscite for a new democratic social contract. So that's one point. The second point is, this is a world-changing event. It's not just a health crisis. It's not just an economic crisis. It's a time that the world after this will not be the same if we can contribute. So I usually tell my students, this is really ant-like work, and you have to just keep plodding away. And I do believe that, but I think that we are in a time of radical upheaval that we need to seize upon, because it won't last. We know all the forces that will try to stop change, that will try to push us back or push us to an even greater austerity. But there are transformational possibilities opened by the sweepiness of this pandemic. I hope that the kind of historical perspective shows that this is not inexorable. We can have a Green New Deal, international New Deal. The decisions that were made along the way were conjunctural, and we can make different decisions now. But that will take changes in the praxis of human rights to focus more on interlinkages with other social struggles across silos, as many people like to talk about now: health, environment, climate crisis, etc. The different syndemics we're facing. But I also think it's going to take more than just looking at human rights law. It's going to take looking at a variety of different laws and the ways in which we can take back a democratic political economy. So I'll stop there. I hope I haven't gone too far over, and I'm happy to answer questions. Thank you very much.
That was wonderful. Thank you so much, Alicia. Thanks for sharing your expertise. And it's great to get this socioeconomic rights perspective. And that was such a rich and holistic exploration of these various issues. So thank you again. And now I would like to hand the floor over to Professor Benedict Kingsbury, who joined us at the initial conference on the 15th of July of this year. So Benedict Kingsbury is Marianne Edith Becker Professor of Law and Vice Dean, as well as Director of the Institute for International Law and Justice at New York University School of Law, and will speak today about Hobbes and the plague doctors. So I'll hand it over to you. Thank you in advance, Professor Kingsbury.
Hi, well, thanks very much. It's really nice to be with this whole group, and nice to see many friends and colleagues. And I pick up on several of the themes that Alicia has just addressed, and really I'm speaking from work that the late Sally Mary and I had been doing jointly. We'd edited 2 books on indicators, rankings, and forms of power and global governance, and we'd begun to work on big data. And the last 2 years, she and I had been running a project on infrastructure rights and regulation, and we had been aiming to develop that to a big scale jointly, and I'm doing my best now to carry it on, tribute to Sally. So this topic is going to be a mixture of very macro and quite micro, and the macro is really setting a context which I think overlaps a lot with the one which has been mentioned by all of the speakers so far, and that's how to think about the responses to epidemic and in relation to kind of core political orientations, what pressure it puts on matters that have been papered over, and to what extent kind of core assumptions are coming out. So if I can, I'd like to start with Hobbes, and this is the famous frontispiece to Leviathan from 1651. Hobbes didn't draw this, but it's strong evidence that he indicated the kind of things he wanted there. And of course, as we know, the dominant image is of the Stuart king-like person who's the Leviathan, and if one looks a bit more closely, one sees all the human beings, the different garb and social ranks, that multitude is formed into a single body politic in the person of the Leviathan, which of course need not be a single sovereign, but that's what Hobbes tended to prefer. So there's also down the front city, and when we look more closely at that city, we see that there's not many people in there. The people, we presume, are all up here. But the people of the walled city, there are some who are military on guard and parade ground area there for their weapons, and there's 2 other people here. And those people, as now many, it's a very good work in German which worked out this iconography and it explained that those people are plague doctors. That is, they're wearing the long mask with the herbs and perfumes in it, that it from about the 1640s had become by no means universal in Europe, but it was used and was also a symbol of the medical people who engaged with the plague. Now, how to interpret that? Why are those plague doctors there? Well, I think the usual interpretation is probably that Hobbes thought that war, especially civil war, but also external war, is one of the core reasons why a state is needed, to get out of the state of nature. But another is to cope with really fundamental emergencies which are not driven by humans, but which have to be addressed collectively, a different kind of state of nature. And the plague was, of course, the direct life experience there, and also historically very fundamental. So the usual assumption is that the sovereign and the powers of the sovereign are part of the way of responding to this kind of public health emergency. I think it's the standard interpretation of Hobbes. I want to, though, take it in a different direction, which is to try to consider why it is that these doctors are the only people, apart from the soldiers, who are separated off. Why are they not simply part of the multitude? Why is the science medical establishment not simply included in the multitude? There are a lot of people doing important work in the multitude, and why would it be that these doctors have to be there? Now, it may be purely symbolism, nothing more to say about it. I don't mean really an exegesis of Hobbes at all in this, but more to reflect on the way in which medicine and science have been differentiated in the kind of modern period, certainly of classical Euro-Atlantic type thought, from some of the other core elements of politics, even though, of course, they overlap. And that's the intellectual starting point, which I'm going to then take to a specific in a moment. Now, the familiar kind of modern work addressing these kind of things is Foucault, and many people will be well aware the kind of standard that Foucault's account of the fearsome deployment of state power, people being locked in their houses during an epidemic and not allowed out, just food being shipped in there. That account in Foucault is one which seems again to very much emphasize state power. Usually it's cited as a critique of the state, and it's also the way Foucault presents it is the encapsulation of the idea of biopolitics and drivers of political activity and perhaps legal activity in biopolitics, and that's how Agamben and others would interpret it, and what's widely used that way. And there's plenty of support for that in the way people now understand the responses to the present epidemic. And I think we can add to that the anti-imperialist sort of suspicion of the kind of global dominations and inequality that have gone along with many of these things. I just took this image of the British government in Mumbai, the 1896 plague, where now in the post-colonial literature that is treated as an episode, it had spread through the British Empire. It had come from Hong Kong, probably, to Mumbai. It was fearsome there. It's treated as an episode of kind of colonial over-policing, over-ferocity, followed by colonial neglect, with the idea that there was a first of excessive policing type reaction. And after the British realized that the white population was mainly not affected by this plague, they seemed to lose interest in it. There's much more to say about the history, but that's a standard interpretation. And we see here the deployment in that government of the kind of groups that are going to address this. And as you see from that picture, it's quite a mixture. People with ambulances, medical people, colonial authorities with pith helmets, various kinds of soldiers. Now, the dominant image again is the Hobbesian one, all these soldiers lined up and forcing people to take part or to accept what was being done in response to the plague. And here's a pretty typical set of measures, forcing people out of houses, disinfecting, spraying disinfectant almost everywhere. At that time, there was enough evidence both that there was a bacteria which caused the plague and that there was some vector, the rats, it turned out. There was just emerging that evidence, but the British didn't internalize or act on it, partly because they were sure that it was the filth of the Indians, especially the poor Indians, that was the cause of this thing. And so some of the measures were, in fact, had the effect of causing the rats to leave where they were and moving to other places and spreading plague. So that would be a kind of typical understanding, and I think a continuing part of suspicion of some of the public health measures. So But I think there's also an element in which the idea of science and medicine as special, as perhaps something to be somewhat preserved from pure politics, something not just subordinated to power, even though power is woven into that, has also been significant. And we see that also around the world. If we think back to Thucydides, we find in Thucydides that passage which describes the disease. No one knows what disease it was. It happened in Athens in 430 BCE, but describes the symptoms. He himself suffered from it, didn't die. Pericles died, many others. And he also says, well, the doctors tried to treat this, but they didn't know what it was. They didn't know at first, he says, at first how to treat it. And the doctors died in the biggest numbers because they were the people who dealt most with the patient. So there's that element even there of treating that very descriptively, the plague, in a sort of scientific type way, observationally, not the case with how he writes a lot of other things, but in that way, but also that element, actually not of rejection of medics, not of despair, but of taking it quite seriously. So that tradition, I think, is an interestingly divided one. Even before the kind of science we associate with the 17th century onwards, it has this sort of special place, and we see that, I think, in lots of parts of the world. So I want to move from that rather abstract observation, but to try to tease out one element now, and I'll stop sharing my screen because I just want to talk to this a little bit, which is to talk about data and the sharing of data. We have a project on global data law at NYU here that I'm heavily working on, and with a group of others, Thomas Streins and Angelina Fisher especially, and just drawing on some things from there. That's the ways in which data about epidemic diseases is shared. And of course, there's a framing in the World Health Organization, the international health regulations. We've talked about a lot of this in the previous one of these conferences, so I don't want to go back down that track, but I've been looking quite a lot at two of the main data sharing arrangements. One is Genbank, which was created in 1982. It was originally housed in Los Alamos National Laboratory in the US, and in 1992 was moved to the National Institutes of Health, where it still is. And that is a public, globally accessible database of genetic sequences of many sorts. And it includes, there's proteomics, and there's a lot of things in there, but it's nucleotides of different sorts, sequenced, available digitally, and it includes animals and other kind of organisms as well as human genome material. It got its big energy and activity through the Human Genome Project at the end of the 1990s. So it's centrally important worldwide, and it's accessible from everywhere. And there are very few obligations if you use that data. So that once the sequence is available there, you can use it for almost anything, including commercial purposes and publications. Now, the second of the platforms is GSAID, which was created during a period in the 2000s when there was concern that the Genbank was putting restrictions on some access to data. It wasn't being done for kind of macro geopolitical reasons, at least it didn't appear that way. It was to do with the basic problem that many scientists who are working day and night in labs trying to extract and sequence genes or other material, we're doing all that work. If they then publish the sequence or put it up on, didn't publish it, sorry, if they put it up on a database, someone else might use that and publish the main paper on it. And those people would not be recognized in career terms. It was a problem anyways between experimental science and data analysis kind of science, and a real concern about attribution, recognition, grant funding, and so forth. So and that's been a continuous challenge. Yeah, the micro incentives, which are important for the individual scientists and their careers, versus the rapid access to data, which will enable other people to use it. So the common phrase was being scooped. So GSAID was created, it's centered it's in Europe. It's hosted in Germany by the German government with support from the US and Singapore, but it's a non-profit foundation which it provides the core governance, and there's a large number of volunteers who do the data curation. Both of these databases do important things. They don't just leave the data as it arrives, they curate it. And And there's a check it for quality of the sequencing, look for duplications, things like that. And also, importantly, they give an accession number, which makes that a unique sequence in order that when it appears in published literature, everyone knows it's that sequence and not something else. So it's an important set of functions which are added here, which will add value to this thing. Now, how to think then about those, what are some of the main approaches? Well, where Sally and I, and now a group of colleagues around the world working on this, thinking of this from the framework of infrastructures, and especially as a form of knowledge infrastructure, which will have these technical elements that I just mentioned, including the informatics, the server capacity, the organization elements, who's going to host it, how it's going to be governed, and the kind of social elements, the scientists, the people producing the data, the people using it, etc. And there's a whole set of norms there, most of which are more norms of scientific etiquette. Sometimes they're set by funders or journals, and there's a structure of what formal terms aren't legal norms, but often enormously influential. So that's one side, is seeing this as infrastructure. A kind of second side is to see it as platforms, and to think of these as having some of the qualities and similarities with the more familiar big tech kind of platforms that everyone knows about. And a platform has tended to be programmable, interactive, sort of multi-sided, but there's the potential here to build things on top of the platform, to run AI on the sequences, for example. That's what the informatics field is about, and to create apps which can use those things. So that's the second element, which really focuses especially on the business and incentives elements. And then I think a third is the idea of this is some sort of commons, a sort of open science commons and knowledge commons, perhaps in the Ostrom type tradition. And the states, especially if we think of the US, has done a lot of funding here and done a lot to try to drive this as a commons, in which case we have the classic problems of commons governance. What are the incentives to contribute to it, to maintain it, to not deplete it, etc. There's much more to say on all of these, but just how to think about it. Now, how does this relate to international law? Well, there are several headings, at least, that I'm trying to work on here with my colleagues. One is this ties into global data law. Is there an obligation to share data? And if so, where does it come from? There's a lot to say about that. Is there a human right of people to have data, to have access to the data, either as data or to the benefits of it, which is that long-standing human right to share in scientific advances, which have been really very underdeveloped. Is there an obligation to conduct surveillance? Of course, in the IHR, well, there is, but does it require sequencing, things like that? What about the global maldistribution of sequences? And then the arrival from US and Chinese companies in particular of lots of sequences in Africa in particular right now at high speed, but in many other places, and the concern about extractivism, which goes with that. And conversely, in data is the data protection rules, which at least in relation to human relevant data, it can be quite significant. Okay, so there's one zone of law is the data protection. I think the second has been the long-standing discussion of virus sovereignty. Are these viruses somehow, is there a sovereign right to them of some sort linked to origin, to where it's found? And this is the Convention on Biodiversity, Nagoya Protocol kind of line. And there's been efforts to compromise on that before, in particular to try to, in relation to pandemic influenza samples, to send back some sort of benefits. That really doesn't apply, though, to sequences. There isn't any structure for sort of return of benefits and sequence sharing. And in fact, there's an interesting idea and question whether biological samples are treated in a different way in this sort of understanding of sovereignty than pure non-materialized information, that is the sequences. And there's also an important set of questions about kind of what you might call digital twins, the relationship between what you might call the world, that is the virus, in people and wherever it is, and the rendering of it digitally, and whether there's actually separate regimes of governance of those two things, or they are fused or should be fused. And then I'll end here. I think finally we see at the moment a kind of overlay now of geopolitics and securitization again. And we might say, well, this is somewhat driving back to Hobbes, and everyone's familiar with it in relation to COVID overall. But I think also this tension about these purely open models, who are the beneficiaries of them? Do they tend to be hegemonic? What's the distributive element? and how are they going to play out as this increasing tension in the US in particular about those models and about China and development building on it starts to change attitudes to policy on these things. I think I'll finish there. Glad to discuss.
That was absolutely fascinating. Thank you so much. Great to get the historical, philosophical, as well as medical and science angles, but in particular to hear your expertise on global data law and the ramifications of that for the current pandemic context. Thank you so much. So now I'd like to introduce Patricia Tuitt, who is an accomplished legal academic, formerly Professor and Dean of the School of Law at Birkbeck, and will speak about COVID-19, Brexit, and a post-colonial critique of the EU. So without further ado, I'll hand the floor over to you, Patricia.
Thank you, Donna. Can you hear me and see me? Great. Okay. Well, first of all, can I thank you and the other organisers for giving me the opportunity to present today. And what I want to do is to focus on the implications of the coronavirus emergency on the legal academy, and specifically on scholarship within the field of public international law. Now, whilst COVID-19 does not immediately indicate, at least not to me, the need for investigation of new areas of study within the field, it does suggest the need for intensification and acceleration of scholarship which examines the colonial underpinnings of public international law and the institutions that sustain it. And in saying this, I do take full note of what is now several decades over which 12 scholars, third world approaches to international law scholars, have critically challenged public international law for its colonial foundation. So I do want to give full recognition to that body of scholarship. However, certain international legal entities have, relatively speaking, been insulated from such critique. And the European Union, I think, is a case in point. So as far as my research is concerned, it's mainly within the field of international refugee law and the European Union. As far as my research is concerned, it's a little too soon for me to say something definitive about COVID-19 and the European Union. But there are indications that the colonial histories of European Union member states and the EU's colonial forms of governance stand in the way of effective responses to contemporary global problems, not just global pandemics, but other problems. For example, in terms of the colonial histories of member states, it's often been observed, and other participants have already observed, that the government responses to the pandemic have brought into sharp focus pre-existing structural inequalities. And this is certainly evidenced in the colonial conditions that compelled Black, Asian and other racialized communities towards the essential work sectors, the public transport, delivery work and so on, those sectors that now expose them disproportionately to the virus. So that the particular conditions that they were faced with under colonialism meant that they were forced to this kind of work, and we're now seeing some of the legacies of that. But also we can say something about the colonial forms of governance. The colonial state is one that sees itself in a constant state of emergency. It is ever poised to confront the consequences of its illegal imposition. That's why it's a sort of emergency form of a form of governance that sees itself in a permanent state of emergency. And one particular legacy of colonialism is arguably evident in the mode in which EU member state populations are governed in current times of real emergency. So again, to take a couple of, an example from the UK, but this doesn't just apply to the UK, and probably goes beyond the European Union as well. Despite many striking examples of efficient and effective mobilization by local communities in response to humanitarian emergencies, and let's take the Grenfell Tower fire emergency, for example, this model of governance only recognizes the agency of state-led organizations, and that's just one example. And this model of governance is, of course, one which the law plays a pivotal role in shaping. If we take the UK's response, legal response to coronavirus in terms of the Coronavirus Act, for example, we can see that the law, it doesn't just confer powers on some and impose obligations on others. What it does, most importantly, is to construct a narrative about why the society on which the law will operate is in need of further ordering. And so this top-down, essentially disciplinarian mode of crisis governance ensures that populations become overly dependent on forms of state-engineered emergency social assistance, and as a result of this dependency, the population arguably becomes increasingly vulnerable to oppressive displays of governance. So to repeat, I'm not really here to say anything deeply significant about COVID-19 as such, but it is one of two recent events that has made me aware of just how far away from a sustained post-colonial critique of the European Union we are in the legal academy. That's one event. The other event is Brexit, and I've written quite a bit around Brexit. So these are the two things that maybe reflect on the state of scholarship within around the European Union. This is not to say that questions of colonialism were not posed in the context of Brexit. On the contrary, since the outcome of the referendum that was held on the 23rd of June 2016, a mode of writing about Brexit has emerged, which attributes the UK's decision to withdraw from the European Union to a melancholic longing for the period of the British Empire. And of course, I am broadly in sympathy with these accounts, but I'm also troubled by their silence about the colonial histories of other European Union member states. Although creating much smaller empires than did the British, the EU as a whole is composed of member states which were to varying degrees deeply invested in the long period of European colonization. And this concern, the concern around scholarship that talked about Brexit and in colonial nostalgia, that led to a publication, a recent publication in the journal Law and Critique, which was titled European Empires in Conflict, the Brexit Years. And in that, I wanted to interrogate the scholarship around Brexit and colonial nostalgia, and therefore the publication took the form of a review article. In essence, it argues that the UK's decision to leave the EU, and especially the tensions and reversals that have marked its attempt to negotiate a withdrawal agreement with its EU partners, reveals just how strong is the colonial lens through which EU states as a whole see the world and relate to each other. And I won't have time to say much about the detail of that article, but the second half is very much concerned with the way the states invoked old colonial tropes and techniques in their negotiating process. And I look at three documents: the Brexit White Paper, which was the British government under Theresa May's first attempt to present what the UK would look like outside of the EU, and then the two withdrawal agreements, and explore that. So now, what I do want to make clear is that I'm not saying that the Legal Academy has entirely neglected a post-colonial critique of the European Union. That would be unjust. There is a respectable, albeit very marginal still, body of works which highlights the EU's adherence to classic modes of sovereign assertion, talks about its embrace of a denigrated notion of citizenship, its treatment of resident non-nationals and asylum seekers, and of course its overwhelming preoccupation with economic actors and economic spheres of activity. But legal scholarship on the EU as a whole is yet to enter a decolonizing phase. And by this I mean that the field is not underpinned by the educational practice which the editors of the 2018 volume Decolonizing the University advocate, and which I entirely agree with. And they talk about this as, and I'm quoting here, a way of thinking about the world which takes colonialism, empire, and racism as its empirical and discursive objects of study, unquote. And what I think the Brexit case shows is that the gains that, and other examples where discourses are engaged in times of emergency, so Brexit may be, COVID may be a case in point as well, although I'm a bit more tentative about that. What I think it shows is that the gains that existing post-colonial critiques have made are undermined by discourses which seem to function by separating the colonial histories of EU member states from each other, and even more problematically, by separating these histories from the colonial underpinnings of the European Union itself. So, both COVID and Brexit really got me to thinking about what it is about the European Union, what is particular about the European Union that has, relatively speaking, insulated it from Twale and other critical accounts of international law and international legal institutions. And here I do, to a large extent, indict the Legal Academy, which I think has all too successfully asserted the European Union's unique nature. As we all know, the textbook articulation of the European Union is as a wholly unique political and legal entity. In other words, it's an entity that is without historical precedent, and that's the textbook articulation. And I think this greatly discourages any kind of historical critique, much less a search for the EU's colonial underpinnings. And I did perceive this problem very early on during my time in teaching EU law at Birkbeck. And as a modest form of response, I published a series of articles over roughly a 4-year period, I think between 2010 and 2014, in which I sought in various ways to argue that the European Union is a glaringly, I felt, obvious example of the colonial discovery doctrine at play. And according to this doctrine, a political community that is deemed to have reached the limits of its economic and social efficacy is imagined as waste or desolate, and as a consequence of that designation, as a consequence of that imagination, is then open to radical alteration. And similar to many legal entities that preceded it, the EU, as we know, was settled by the migration of people and by the free movement of other factors of production. That intense movement around the European space was the factor that gave it its force, its vitality. Also, like so many legal entities that have come before it, the European Union survives, one might say even thrives, on a discursive terrain which places emphasis on the failings of what came before it, in this case, in the nation state form. In conformity with the discovery doctrine, the old modern Europe had to be conceived of as thoroughly bankrupt before it could be appropriated to the resolutely post-national and post-modern aims of European integration. In essence, what I would try to argue in these articles is that far from witnessing the birth of a political community without precise historical precedent, the origins of the European Union are in fact distressingly familiar and traceable to a very particular colonial time and sets of techniques. I don't have the space to elaborate the argument here actually, but just on a very quick Google search yesterday, I noticed that one of the articles, which was published in 2012 in the Columbia Journal of International Law, appears to be open access. So anyone who might want to see that, it's titled "Used Up and Misused: The Nation State, the European Union, and the Insistent Presence of the Colonial." I'm running out of time, so I'm going to fast track to 2020 and to that part of the review article that I mentioned earlier, The European Empires Are in Conflict, which examines the European Union's far from unique mode of sovereign assertion. And this, of course, connects to, just to remind you of the overall premise of my argument today, which is that the colonial histories of European Union member states and the EU's colonial forms of governance stand in the way of effective responses to contemporary global problems. Because, of course, the potential breakup of the European Union, which Brexit posed, one might say still poses, is certainly a problem that will have global implications. And observing the near 3-year period of the Article 50 negotiations, one is bound to question whether the EU's time-worn strategy of preserving its authority by aggressively asserting its supremacy was appropriate when applied to a member state faced with the painful decision of whether to leave or remain within the European Union. To put it another way, the Brexit situation, and I think possibly also COVID, although I need to do much more work on this, opens a space for reflection on whether there are ways in which the EU, via its institutions and its institutional framework, can express its supremacy through new discursive forms, and new forms which do not endanger the relationships of solidarity and mutual trust among member states, without which the EU project is destined to fail. And that's one of the questions that I pose in the article, and I'd like to develop in different contexts. Now, whilst I was fairly clear in the article that the EU was in error in attempting to address the Brexit question through the supremacy lens, what I want to emphasize here is that that approach was almost an inevitable result of a colonial legacy that dictates that a state of emergency form of governance is the only viable one. Thank you.
Thank you so much, Patricia. That was so interesting. It's great to get the regional perspective, but also to shine a light on the historical features of the EU that haven't necessarily been recognised or critiqued till now, and also to look at the role of the Legal Academy in addressing or potentially perpetuating these issues. So hopefully we can come back to that in the Q&A. Thank you again. And then next up, we're delighted to welcome Professor Aya Fujimura-Fansalau, who is Clinical Professor of Law and Supervising Attorney of the Duke International Human Rights Clinic at Duke Law School. And Aya will examine social movements and COVID-19. So I'll hand the floor over to you, Aya.
Thank you so much, Donna, and thank you to Donna for the invitation and to the panel of students, and very happy to be here today with my fellow panelists. I'd like to explore two main questions today with respect to social movements as Donna introduced the topic. First, to think through what are some of the challenges that social movements are facing in the current moment given the COVID-19 pandemic. And secondly, in light of these challenges, what are some strategies that movements are using? And how might we think about how these strategies inform the future work of social movements? And my reflections are informed by a wider universe of research, including looking at some movements that I worked with previously when I worked with the International Network for Economic, Social, and Cultural Rights. But I'd actually like to base my reflections on 4 primary examples. And I chose 3 examples from Nepal, where I worked for about 2 years previously, actually with the International Center for Transitional Justice when Juan Mendes, who you'll hear from next, was president. And 1 example from Santiago, Chile, where I spent a very short amount of time last year at a conference. And because of former colleagues and friends in these places, I had some extensive discussions with movement leaders. And so I'd like to draw on the examples and reflections that they shared with me in our discussions. And so I don't mean to suggest that these examples reflect trends across all movements, but I'd like to offer them as key examples. So briefly introducing the movements, the first is Adhikar, which is an organization, a movement based in New York, whose members are Nepali, domestic workers, and nail salon workers. And the movement aims to advance social justice found in dignity and equity, with Nepali voices at the center. The second movement is called Samsaj, which is the community empowerment and social justice movement based in Kathmandu, Nepal. And this is a network of activists that focus on socioeconomic empowerment and promoting the human rights of marginalized groups. And Samsaj is made up of indigenous peoples, Madeshis, Dalits, persons with disabilities, and they also focus on women and children. And the third Nepali group is called COVID-19 Support Nepal, which is a group of individuals from different marginalized communities in Nepal who came together to create an open source, community-owned platform to address both immediate and long-term impacts of the pandemic. And the fourth group is a mutual aid group in Santiago, Chile, one of many, but I was able to speak with the leader of this movement. So first, what are some of the challenges that social movements are facing in the current moment, given COVID? And I'd like to mention 3 challenges in particular. First, that simply the health risk of gathering in large numbers for protests and rallies has been a risk for many. And this has been a primary strategy for social movements in their work historically. And so this brings up questions about adaptations they might have to make. Secondly, the pandemic and other events have made the work of social movements even more urgent at a time when it's been more difficult to organize in some ways. So for example, the pandemic has highlighted severe inequalities, including racial disparities in developing and dying from COVID, and brought further to light the non-guarantee of economic and social rights, including the right to health, housing, food security, among many others. And Alicia Yamin mentioned earlier this idea of the pandemic as the great revealer. And as she noted, for many of us and for social movements, these issues have been apparent and obvious all along, but many who had not been fully aware are in some cases noticing and being incentivized to act on some of these issues. And relatedly, the police killings of Black men and women in the US and elsewhere, and the repeated failure to respond to these killings has continued, including in recent days with the failure to indict officers involved in the killing of Breonna Taylor. And so the urgency for this continued organizing has only grown, with Black Lives Matter and movements globally continuing to mobilize. And finally, as a result of the pandemic, governments globally have put into place a range of measures, often emergency measures, as raised by both Professor Helfer and Amina, that place restrictions on the right to movement and assembly, including suspending constitutional rights and freedoms that directly impact on the right to gather and protest. And many of these laws that prohibit protests and gatherings are under the guise of public safety, but often either explicitly or implicitly target certain groups, including activists. And we've of course seen too many examples of law enforcement using brutal and even lethal force to respond to behavior. We've also seen elsewhere the resurrection of old laws. So Samsaj in Nepal has noted the ways in which the pandemic has given pretext for more monitoring and the deployment of state security forces, including under an age-old Infectious Diseases Act, combined with public disorder laws that have given really wide-ranging powers to government authorities with little reference to rights. And just a few weeks ago, police in Kathmandu used excessive force, including firing 50 rounds of tear gas, and arrested multiple activists, indigenous activists, who were then infected with COVID during their detention. So turning from these challenges to opportunities, I'd like to focus on 4 ways in which movements have turned some of these challenges into opportunities. And while I do see these as quite positive opportunities, I also do want to acknowledge the really intense physical and emotional exhaustion and impact of the pandemic on movements, given that we're talking about people who are, in many cases, directly impacted. So the first opportunity is to look at the ways in which movements are adapting their strategies. And in some cases, this has meant resurrecting strategies from the past. In other cases, this has involved quite dramatic changes. So in terms of pulling up strategies from the past, the mutual aid group that I spoke with in Santiago, Chile, or Ollas Comunes, have been very active. And these are mutual aid groups that were used previously, including during the dictatorship, as a means of community survival. And going even further back, they can be traced to traditions and communal practices of indigenous groups and women of the African diaspora there. In terms of strategies that were not used previously, we see social movements adapting in order to continue to be responsive to their members' needs. And while the ability to adapt and innovate has always been central to the work of social movements, we see it happen now in ways that are perhaps especially dramatic. And this might allow us to rethink and expand our thinking about effective social movement strategies. And while they've been adopted as a form of survival in the current moment, they might serve as lessons going forward for effective movement work. One example of this is the move into digital spaces. So at the beginning of March, for example, we saw the Sunrise Movement in the US tweeting, quote, "Due to the COVID pandemic, we're asking organizers to avoid mass physical gatherings and encouraging its members to think creatively about what it means to strike with us, including through internet and social media, saying, quote, it's time to innovate, especially digitally." And of course, this does present enormous challenges for many communities and raises concerns about digital exclusion and lack of access to technologies. In the case of Adhikar, the movement I mentioned earlier that works mostly with domestic workers and nail salon workers in New York, many of their members were not only digitally not literate and without access to internet or computers, but they had limited literacy even in reading and writing their native Nepali, really compounding the challenges. But to be able to continue their movement work, Adhikar found ways to address this, holding trainings on Facebook Live, for example, which was a venue that members were more comfortable with, about how to use Zoom. And this has allowed them not only to continue their movement work, but also to provide a sense of community at a time when people are feeling very isolated. And these additional skills that members are developing can be carried over, of course, into the future. Adhikar's members are already savvier and more confident in their use of digital technologies, helping to transform what has been a constraint for many of them into a power, and allowing them to participate in spaces previously unavailable. I think this has also triggered other movements to focus on the need for greater equality with respect to access to technology and the internet as well. Another adaptation that I wanted to share is one made by the movement Semsaj in Nepal. And Semsaj has transitioned to more international strategies as a response to the pandemic. So together with other affected communities and movements in Kathmandu, they've been opposing the construction of an expressway that would displace indigenous Newar communities and violate their land and resource rights, as well as destroy cultural heritage sites. And these movements have had to suspend the protests and rallies that have been the focus of their movement work since 2016 when this first came up. Similarly, these movements had worked with lawyers previously to file petitions before the Supreme Court. Again, once the pandemic started, this was no longer an avenue that was available to them. And so given the inability to gather in person for demonstrations and given the inability to engage with the judiciary, but not wanting to stop their work, especially as the government was now accelerating construction, the movement has turned to international mechanisms, thus expanding the scope of their activism to encompass new stakeholders and new mechanisms, and building their own expertise and skills. And specifically, these several movements have mobilized international solidarity and assistance, calling on international and UN entities, including UNESCO, the ILO, and UN country offices in Nepal to take actions under their mandate, including to raise the issue with government officials and facilitate dialogues with movements. A second opportunity, which has been an unintended positive consequence of the current moment, is the increased chance for relationship building in a range of ways that's impacting current work and also likely to have long-term consequences. And this solidarity building is perhaps a less visible and less tangible form of activism, but I would argue that it's really essential and core to movement building. And the fact that this has been an unintended result encourages us to think about different ways to define and measure impact of movements. And I'll just share just a couple examples of the different forms of relationship building that we've seen. So first is relationships between movement leaders. The COVID open platform movement in Nepal that I mentioned earlier, made up of people from different marginalized groups, included people from people who are indigenous, queer, transgender, and Dalit. And because these individuals had to suspend some of their own in-person activism related to their individual movements, this opened up a space for organizers to step back and reflect together more intentionally and more deeply on relationship building in ways that looked beyond their individual movements and issues to more common struggles. Again, looking ahead, I think this can set the stage for a more collective capacity in leadership, working towards transformative change. We also have seen examples of more relationship building between movements across racial and issue-based lines. So in the case of Adhikar, the pandemic has resulted in more multiracial and multi-ethnic collaboration and campaigning around workers' rights, especially given the centrality of the Black Lives Matter movement. And my final point, the proliferation of mutual aid groups has created an opportunity for community building that might impact the work of movements going forward, serving to build stronger and more expansive bases for movement work. So for example, the mutual aid groups in Santiago that I spoke with have been a form of collective learning as people learn to organize from the bottom up. Unexpected relationships founded on trust and solidarity have also formed, as mutual aid has both literally enabled the survival of many people in the most dangerous and poverty-stricken neighborhoods in Santiago, but also led to more profound relationships in some ways, as community members have repeatedly said, "Thank you for seeing us, gracias por vernos," when they enter, when these members of the mutual aid group enter their communities, reflecting the ways in which they've been abandoned by the government and by contrast, seen by their neighbors. In participating in mutual aid groups, there are also ways in which some of the foundational causes of inequality and injustice are brought to the forefront and addressed. So another mutual aid group in Santiago, Chile, called LELAC, is made up of lesbian feminists, anti-racist, dissidents, migrants, and indigenous persons. And they've organized to support lesbians and trans persons in need of food and medicine. At the same time, they've sought legal assistance for their members, especially to address discriminatory treatment and violence that they have faced in health facilities. And also really building on the protests that occurred in Santiago last year, denouncing Chile's entrenched inequalities, they've not only been addressing daily needs, but also some of the broader systemic issues at the same time. So looking ahead, I think it would be important for all of us to think more about how movements are sharing some of these adaptations transnationally, and to think again about how these adaptive strategies might translate into further work, as well as how we think about how we measure the success or outcomes of social movement work. And I really also just wanted to mention here again how grateful I am to the movement leaders from all of these groups that really took the time to share their reflections and strategies with me. So I'll end there. Thank you.
Thank you so much, Professor Fujimura Francolo. That was an excellent and very important overview of certain movements that may indeed inform the way other social movements are progressing and learning in the current pandemic context. So thanks for shining a light on complex challenges facing social movements and potential opportunities in the future. And I know one of the students has a specific question for you in the Q&A, so we will come back to this discussion. Thanks again, and I'll now introduce our final speaker, who was, along with Professor Kingsbury, the other speaker who was also involved in the 15th of July conference. So we're delighted to welcome you back, Professor Juan Mendes, who is a professor of human rights law at American University, Washington College of Law, as well as you all know, former UN Special Rapporteur on Torture between 2010 and 2016, and who today will speak about the right to liberty and prisoners in the context of COVID-19. So I'll hand the floor over to you, Juan. Thank you.
Thank you very much, Professor Dr. Lyons, and I also want to thank Trinity College Dublin for giving me a second chance to join this wonderful seminar. I will talk about how COVID-19 has created a real crisis in prisons all over the world, but I can't resist the temptation of joining the debate about the use of standards of international human rights law to combat the coronavirus. 6 months into this really strange life that we have to live, there's still debates and criticism of measures taken by states to protect all of us from the disease. And some of these criticisms come from a perspective of some kind of libertarian ideology that proclaims sort of Ayn Rand style that the individual has a right to resist any kind of order from the state. Sometimes I've seen it couched in terms of fostering civil disobedience, which would come as a big surprise, I think, to Mahatma Gandhi and Martin Luther King as to what uses civil disobedience can sometimes lead to. But I want to be counted at least as a skeptic about whether we should encourage states to use the standards of derogation in international human rights law, and particularly to declare states of emergency. And the reason why I'm a skeptic is I come from Latin America, and I've lived long enough to have seen how states of emergency have been abused and have become, sometimes literally for decades, a way of governing rather than an emergency situation. But I do take it and understand that Professors Helfer and Adanan are arguing about using the normative framework of states of emergency as currently developed over 70 years of normative development in international human rights law. And with that, of course, I can only agree, because we have come to understand that states of emergency have to be carefully seen as not permitting the kind of abuses that we have seen in Latin America. Nevertheless, I think we have seen how the COVID-19 has allowed some states even to suspend elections without even trying to justify that there's another way of letting the people decide who is to govern, or without exploring protocols in which the timely replacement of governments through the ballot box should nevertheless be exercised. And of course, I should add here that under the American Convention on Human Rights, as it applies in Latin America more generally, even that is prohibited by the derogation clause, because the right to political participation in the continent for the states that have signed and ratified the American Convention is one of those non-derogable rights. Nevertheless, I do think that states are entitled, if they don't wish to declare states of emergency, to take measures to combat COVID-19 that are based on the theory of restrictions and limitations on the exercise of rights rather than on states of emergency. As we know, and has been very well developed by the European Court of Human Rights, all rights are subject to restrictions and limitations in their exercise, as long as those restrictions and limitations are provided by law. They pursue a legitimate aim, they are proportional to that legitimate aim, and they're necessary in a democratic society, which means that ignoring the possibility of state of emergency doesn't relieve the state from its obligation to be very careful and measured in the way that it takes extraordinary measures to combat COVID-19. And the important thing is that whether a state declares a state of emergency or whether it uses the theory of restrictions and limitations, first and foremost, the measures still have to be subject to a control of reasonableness. And the reasonableness necessarily has to be linked to the scientific evidence for the effectiveness of the measure. Even with these norms, some activities may be allowed as long as they are conditioned on the respect of certain protocols. And that, of course, would apply whether we talk about state of emergency or restrictions and limitations on the exercise of rights, because the concept of reasonableness of the measures would still be present. And what are reasonable and non-reasonable measures? I would think, for example, that prohibiting access to beaches in wintertime, when the only people who will use the beaches are surfers and divers, maybe, and I'm willing to hear the other side on this, but maybe too much, maybe unnecessary, maybe therefore unreasonable. But allowing restaurants to serve their clients indoors and then prohibiting demonstrations, which is the exercise of a fundamental democratic right to freedom of expression, don't seem to me to be reasonable. Nevertheless, what I think is important is to seek the cooperation of the public on this and to try to persuade rather than coax people into submitting. And on the other hand, it's a question of enforcement. And here's where my reluctance to accept the states of emergency posture comes forward, because I know that police in Latin America, once a state of emergency has been declared, will abuse their authority. They will arrest people without warrant, including on the grounds that they shouldn't be in the street, for example, where in fact in poor neighborhoods they just don't have any other place to be, and would use a very curious way of understanding flagrancy to say that they had some reason to arrest young people, especially if they are from poor areas or from racial minorities. So in all cases, we still need judicial review. And here what we've been lacking is the responsibility that courts and judges should assume to control the actions of the state and to make sure that with a judicious, pardon the pun, way of analyzing the concepts of reasonableness, but nevertheless being firm about saying this is not reasonable and this should not be applied, and ordering remedies to that effect. Those, of course, the judicial control should function very effectively both in states of emergency and in a theory of restrictions and limitations. In terms of prisons and persons deprived of liberty, what we've been learning about COVID-19 is both the taking of unreasonable measures and the non-taking of reasonable measures. So we compound the situation of persons deprived of liberty because of the pandemic. And I want to quote from a webpage, a Marshall Project in the United States, that tells us how bad the situation is and how very little progress we have made in these 6 months. In the United States, as of a week ago, as of September 15, there have been 125,730 cases of contagion on COVID-19 in US prisons. Of those, 102,000 recovered, which means that there are now 23,000 people sick with COVID-19 in prisons in the United States. What's more significant is that in the week of September 15, there were 5,020 new cases in prisons in the United States. The spikes in some of these states seems to track the spike in the same states in the general population outside of prisons, obviously. So it does seem that there's a correlation between actions taken and not taken in specific areas of the country and the way the prisons in those areas are suffering as well. By now, there's been, according to the Marshall Project, 1,066 deaths of coronavirus in US prisons. And again, in the week of September 15, 49 new deaths. And this is not to count other countries where the information is sorely lacking. There's a lot of lack of transparency. In fact, efforts by states to conceal the information about what goes on in prison, including supposedly, mentioning privacy rights of the inmate, but not letting the public know, not only whether inmates, but also guards and staff have been tested and have proven to be sick, and what kind of treatment they're getting. There have been measures taken, certainly, but among the unreasonable measures that I want to mention is first, canceling family visits without any substitution for it, without giving the inmate the possibility of a phone call or a video conference call, lack of news, precisely. Again, in the Marshall Project website, there are some, really touching examples of people, both inside the prison and outside, the relatives, not knowing what goes on with someone who's very, very sick. In addition, another bad measure, unreasonable measure, is isolation. Very quickly, prisons have gone back to solitary confinement as if it was justified because of the possibility of transmission of the disease. And so those measures have violated principles of under what conditions solitary confinement can be used, and particularly violated the prohibition in international law for prolonged or indefinite solitary confinement. But even when there hasn't been isolation, there's been segregation to put people in a place where they can, they don't contaminate others, but they're also treated. The measures seem to have been in many countries and including in the United States, very counterproductive, because they place them in crowded areas without social distancing between them and without appropriate preventive measures to take care of them, etc. At the beginning, I was encouraged because there were release orders by courts around the world, including in the United States, including the Department of Justice had announced that it was encouraging attorneys general around the federal prison population to release people under certain conditions in order to release overcrowding. But now it turns out that when it came to actually implementing those measures, many local attorneys general resisted that and did not produce release even of people who should not have been in prison to begin with, because they were in preventive detention for crimes not all that serious or violent crimes. And in turn, there were, in many countries, including the United States, people who had friends in high places got sent home without any relationship to whether the crime they had committed or the seriousness of the crime, or whether they actually needed to be protected from COVID-19, depending on the way they were living in custody. But this has been a source of, abuse of discretion, to say the least, when determinations to release people have been made. And in fact, those court orders releasing people, and in some countries, including several thousand people, immediately met a backlash from public opinion and a return to normal, quote unquote, because the media exacerbated the fears about crime rates shooting through the roof if all these people were going to be released, etc. And so, of course, people deprived of freedom, particularly for criminal law reasons, are the last priority in every country in the world. And because of that, we have not yet, at least, learned an important lesson that COVID-19 is teaching us, and that is that the first thing that we have to do is try to come up with ways of turning back on the abuse of preventive detention that exacerbates overcrowding and all its contingent denial of services and benefits, and even the very inhuman treatment that people are meted out in overcrowded prisons around the world. The other important lesson that we should insist on is that it's very important for judicial control to be exercised over the conditions in which people are held in detention around the world, and to do it, as I said before, with a clear standard of evidence and of judicial review, but also with firmness and with insistence on the corrections departments and the executive branch more generally complying with judicial orders. Thank you very much.
Thank you so much, Juan. That was wonderful. It's great to get your insights into the derogation issue and states of emergency, particularly with your own personal experience in Latin America, as well as your professional expertise in human rights. And then also great that you were able to detail information from the Marshall Project and current statistics. As you say, it's a bit grim, but it's important to highlight these issues and to discuss them. So thank you so much. And I wonder whether Professor Helfer would like to do a reply to Amina's comments, or would you like to head straight into the Q&A?
I'm happy. I have responses, but it might be more efficient if we got some of the Q&A, and then I will respond to Amina and also to Juan on one or 2 points. So.
Perfect. Okay. Let's maybe I'll start off the Q&A if you don't mind. I actually just had a couple of points on your own paper, which I found fascinating, and I'll then introduce the students who have particular questions, and then there's some general Q&A down here at the bottom. So just a couple of points, maybe they're not so much questions, but comments. You did mention at one point in the presentation that when a state is being reviewed by a human rights treaty monitoring body, that it may be the case that international human rights treaties which don't have derogations clauses may be mentioned in the review, and thereby the state might be held accountable on some informal basis. in relation to their obligations under another treaty which doesn't have a derogations clause. And I think that's entirely possible, because in research that I've done, and I'm sure you've come across this yourself, which is probably what spurred this on, but that often the treaty bodies, when they're doing reviews and when they're issuing concluding observations, documentation, is they will refer to other obligations under other treaties. So for example, the Committee on the Rights of the Child has reviewed states in relation to their treatment of child refugees, and I've definitely come across references to a state's obligations under the 1951 Convention on the Status of Refugees, you know, I think in principle, the treaty bodies know that they're not supposed to be reviewing obligations under other instruments. And in fact, they directly mention that at times. They do specifically say, well, it's not our role to do this. And at other times, they in fact invoke that kind of discretion without any clear basis. So I think it's entirely plausible that that sort of thing will happen, as you mentioned. And then just another point that I wanted to raise, which Juan has just said now, in terms of restrictions in the case of derogation. So you refer to certain requirements that need to be obeyed by states when entering derogation. So necessity, temporal limitation and justifications. And Juan was just mentioning then on top of that, the necessity for reasonableness. And I think that there's this gray area as to whether reasonableness and proportionality also applies to derogations. So you have such an interesting and ambitious article about the state of play of derogations in the international human rights treaties, how they work, the challenges, and then potential reforms. And in the reforms, you talk about the scope of reforms. And you mention that the distinction between derogations and standard limitations clauses, and the idea that proportionality applies to standard limitations clauses, and that it wouldn't necessarily, traditionally it wouldn't necessarily apply to derogations. The idea behind derogations being that there should be more degree of flexibility in moving away from a proportionality analysis. But I have noticed that proportionality language creeping in to the human rights treaty monitoring documentation. So I'm sure you've come across it, and if not, I'm happy to send it to you. But in April of this year, on the 30th of April, the Human Rights Committee issued a statement on derogations. And it's not a general comment, so it doesn't have the kind of status of a general comment or concluding observation, but it is a statement, and it refers twice to the necessity for proportionality in introducing measures in line with derogations. So in a way that does confuse matters, because it sort of conflates standard limitations with derogations. And therefore, I think Alan Green's argument around the two being so different and having such different applications in different contexts, I think the Human Rights Committee is possibly undermining the notion of derogations, or at best confusing it. And I think that's worth exploring more. So it's just a comment, and I'll leave it there because other people are get in. But just to say, I really enjoyed the article. It was really helpful for me, and thanks again, and thanks to Amina for her comments as well. Okay, so in terms of questions, we have a number of students on here who would like to come in. So first of all, Mairead Murphy, who's an Irish Research Council funded PhD student in Maynooth University focusing on severe labour exploitation, has a question specifically for Juan Mendes. Would you like to come in, Mairead? I'm just going to promote you to a panelist now. Maeve, I'm not sure. Yeah, there she is. Can you hear us, Mairead? Sorry, we might just move on to the next panelist. Slight tech issue there. Okay, we'll come back to Mairead. So just maybe make a sound when you can hear us, Mairead. So second student is Nora O'Brien, who's an undergraduate law student at the University of Limerick and has a question for Patricia Jewett. So I'm just going to promote Nora to panelist. You there, Nora? Yeah.
Yeah, can you hear me?
Hi, yeah.
Hi, hi Professor. So my question is in relation to African countries and COVID-19, and whether the reason that we're not taking medical advice from African countries could have anything to do with colonialism. So I just feel that Ireland, I know, and UK are probably in a similar boat, but that we've taken much of our medical advice from European countries. And I've also heard a lot in the media about America and Australia and New Zealand, but we haven't heard much about African countries. And I think there are many reasons why we should be taking advice probably from African countries, just that they have a lot of experience, I suppose, in comparison to other continents with outbreaks of disease and viruses such as Ebola and HIV. And I've just read a few articles that said that colonialism would have been connected with us not taking medical advice from Africa. And I was just wondering if you have any views on this.
Thank you, Nora. Thank you. I think that's an excellent observation. I'm certainly, you're absolutely right that in terms of experience of managing populations that are faced with humanitarian emergencies of all kinds, that the knowledge and the expertise is very much in the global south. In terms of the best response I think I can give you to the question as to how colonialism plays a part, because I can't give a direct response in relation to this pandemic. I just haven't done enough research. But certainly much of the discussion around colonialism in different contexts, and it includes also the university context, is also about a privileging of knowledge, and that the knowledge produced within the West, within the global North, is privileged above other forms of knowledge and understanding, and this is, you know, across the range of disciplines. It's not just in terms of health. There's been research in relation to all areas of life, including cultural life. So in that sense, I think you're absolutely right that what colonialism, or the legacy of colonialism, infects the ways in which states acknowledge the expertise and competence and knowledge of other countries that were previously colonized. So, you know, but I think the point that you've made in your research about the need to take advice from countries that have a more expertise in terms of managing populations in crisis, I think is very well made. Thank you. Does that partly answer your question?
Yes, thanks very much.
Okay, I think you might be losing, I don't know if it's my connection that's going on. Right.
We can hear you and see you absolutely fine.
Yeah.
It could be at our end, but that was really helpful. Thank you so much, Patricia. I'm wondering, would anyone else, perhaps, would Alicia like to come in on that, or anybody else?
I would like to make a couple of footnotes, both on this actually and on Juan Mendes' presentation. I am a senior fellow at Harvard, and I do teach sometimes both at the law school and the School of Public Health, but I also work for a large global health NGO called Partners in Health, which has a very anti-colonialist ethos, and we have done quite a few of these kinds of webinars looking at all of the experience we had in the Ebola outbreak, in other outbreaks in Africa, where there may not be sophisticated tertiary care hospitals, but there are well-developed, entrenched systems of community health workers who identify patients. Even in Lesotho, which has the worst life expectancy on the planet, Partners in Health has really worked with the changing governments, and only 35 people have died in a place that did not even have oxygen. And that's despite the fact that over half their health budget goes to repaying a debt from the World Bank, going back to the neoliberal rules. So I do think my first slide was, we got this really, really wrong in global health. And we continue in many ways to get it wrong. The banking on the high-tech vaccine that private pharmaceutical companies are going to come save the world with. Instead of, the United States has spent no money on simple public health measures, you know, really simple public health measures. We had no public health system in this country. We had a bunch of different hospital networks. And just going one tiny footnote to what Juan Mendes said, on data transparency, so Partners in Health has actually worked with the staff of Senator Warren's office, and she is going to present legislation soon, I believe, on data transparency in all correctional facilities, including ICE detention facilities, because we work quite a lot against in anti-detention measures. And that's the data. I'm glad to hear the data reporting from the Marshall Project, but the United States has been really terrible, abominable about reporting transparently on prisons or ICE detention, frankly. Okay.
Thank you so much, Alicia. That's fantastic. Would anyone else like to come in on that particular question? Marie,
a quick example. Nora, I'll share a quick thought that came to mind. Is there's an article that we often discuss in our human rights seminar called Savages, Victims, and Saviors, the Metaphor of Human Rights by Professor Matua. And I think this often applies to situations where human rights work traditionally and often has, and very problematically, has sort of had this dynamic where we have the saviors from the global north and the savages and victims in the global south, and that this has been so entrenched in much of human rights work and public health work that when there is such incredible expertise, as you noted, and background in dealing with public health, severe public health pandemics in countries in Africa and elsewhere, that they have not been looked to for their expertise because of sort of this entrenchment. And so I think it really is incumbent, as you've done, to raise this issue and the sort of historical and structural roots of why this often continues to happen. And especially at a time like this, how detrimental it is that looking to that expertise would be really life-saving for many people.
Thank you so much, Aya, for that intervention. And thanks, Nora, for a great question. I'm going to ask whether Mairead can now hear us. Mairead Murphy, can you hear us?
I can, yeah. I
Lovely.
apologize. I have a question for Professor Mendes. So I was wondering, should the increased pains of imprisonment that he mentioned, such as the cancellation of family visits and increased isolation and solitary confinement, due to the current global pandemic, be considered in sentencing practices? And if such practices were to be adopted, what would be the effect then on those already incarcerated or in prison at the moment?
Thank you so much. Juan, would you like to go ahead?
Yeah, very good question. Thank you. I think, you know, it depends on how they're considered. I think in sentence, say for example, if someone is in preventive detention awaiting trial and then eventually convicted, and in the meantime, you know, suffers long-term isolation, for example, I definitely think that those things should be considered as mitigation of the penalty. That is, if the penalty is a number of years, they should be getting some credit for time served for the conditions in which they've been held. The reverse, however, of course, it should not be true. I mean, the fact that someone has to be put in isolation should not be part of the sentence at all. In some countries, the courts impose solitary confinement as a way of executing the sentence, especially with serious crimes, bearing 10 or more years in prison. That I understand is the case in Japan and in China, for example. That violates a principle that the conviction and sentence deprives the the person convicted of the fundamental right to movement and to liberty. But there should be no additional penalty beyond that, because a person incarcerated is still a human being and still carries with him or her all of the rights inherent to human dignity. So again, whether this should be considered in sentencing, yes, as a form of mitigation, but not as a form of, the way to serve the sentence.
That's excellent. Thanks, Juan. Would anyone else like to come in on that from the panel? Mairead, that was fantastic. Thank you for that. We also have Bláthnaid Carney, who is LLB graduate from Trinity College, Dublin. So I'm going to promote you to panelists now, Bláthnaid, and you should be able to ask your question in about 2 seconds' time. Can you hear us, Bláthnaid? Bit slow here today. Sorry about that. So,
hold on. Is that?
Yeah. Is that you? Go ahead. Yeah.
Yeah. Sorry.
Yeah. You're sideways.
Hi. I have a question for Professor Kingsbury, and I just want to thank you for your presentation. I found it really interesting, particularly against the backdrop of Hobbes. And I know from my own reading of Leviathan, depicting the complete absence of the population combined with the military, or boots on the ground, I think it gave an air or a sentiment of a permanent state of siege. And I know you also discussed in your presentation about the overlay of geopolitics and securitization in the sphere of global data law, and how driving back to Hobbes illuminates tensions about open models who are beneficiaries, particularly in how these are going to be ongoing developments with the US and China. And I just wonder, particularly in the context of COVID-19 at the moment, do you think that tensions such as these surrounding data law, data protection law, data collection and harvesting of individuals so far may present itself as a corollary of a sort of Hobbesian siege mentality, whether there are any concerns of that, particularly where not everyone but some actors may try and abuse certain privacy laws currently in place, or whether any concerns similar to these should be tempered with skepticism. As a skeptic of data law, unfortunately.
Well, thank you very much. There's a lot in what you asked. I think we see in broad terms we have a sort of draft paper on this, different basic ordering projects in relation to data and digital issues, but mainly the digital economy, but spreading out now. But one is the US one, which has been very much Silicon Valley open data in the US quite energetically. It tries to get prohibitions on data localization and obligations to allow flows of data into the trade agreements. They got it in TPP before they pulled out, and it's in the US, Mexico, Canada agreement, and it's part of the US agenda. And actually Japan goes much in the same direction. It's hard to see quite exactly why. The EU broadly does that, except for the big carve out about privacy. And as you know, yeah, I'm speaking from outside Europe, but it is a total obsession with the GDPR now. But of course, that's premised on the difference between personal data, meaning somehow personally identifiable, and every other kind of data. And I think that distinction won't survive in the end. Not because of COVID. I think in general, it's a misplaced idea. I realize that's utterly heresy to most Europeans, and there's a lot of reasons for that, but I think there has to be an integrated approach to data, and the GDPR really is an obstacle to thinking that way, even though there's a lot of good reasons it's there. And of course, in Ireland, if you're in the Republic, at least you're right at the center of the regulation or not of the digital corporation. So, so there's that, and then I think China is one of the places in which there's really a different model, which they've been implemented anyhow, and I think many countries are interested in trying to move down that track. India is probably the most intricate, and they have a lot of different legislation or projects or ideas about what in aggregate will be quite an integrated data regulation system, which will see data as a resource, a national resource, including for development of artificial intelligence. And I think that's at the core of quite a lot of this question, is the future uses of data. I think that the epidemic questions, that there is on the one hand the health data topic, which is enormously important, and this quite striking thing that people have so freely in many countries given their data, DNA samples to commercial companies for finding their ancestry or various things like that, including amazingly revealing all kinds of things about their relatives or people they don't know. And it's quite remarkable how unregulated that. So health data on the one hand has had that sort of freewheeling public turning over things. On the other hand, a lot of anxiety in wanting to restrict it. In many countries, there's not much permeability. So I think that's very specific, and some of that will go into the AI field. But I think in the way that's all subsidiary to the big question of data policy, which I think is driven much more by those big picture questions. So I think that line, so far the drivers have been mainly economic for the US and economic, but with privacy in Europe. But I think increasingly this sort of more sovereigntist type idea is going to be significant. And I think you're beginning to see that already in the US pushback against several big Chinese companies in particular. And I think in a way that will swamp the specific epidemic things. But I think the Hobbesian drive, which you see both on the left and the right, people saying we've got to have the state now. And people who never would have said that before have got very keen on the state doing stuff in the epidemics, especially in richer countries. And state in many countries is sort of arrogated to itself those kind of things, as many of the talks we just heard address. So that sort of recommitment to the state, I think, has proved to be not very successful in the data field. I think you see that in France, where they've tried to have a centralized app instead of private companies. The UK, where they've really had to switch back over to the Apple Google type system. And actually, it's proven that the ability of the state to deliver in that kind of data space is quite limited. So I think that tension about having to be commercial and the extractivism, the colonial, post-colonial, and the sovereigntist pushbacks on that, I think that's the big picture of this whole field. And the peculiarity, most of the debates don't have that as the framing.
That's fascinating. Thank you so much, and thanks, Blanche, for the question. So I will move on to Colette Whelan, who's an undergraduate law and political science student, at Trinity College Dublin, and has a question specifically for Aya. Would you like to go ahead, Colette?
Yeah, hi. Thanks for allowing me to ask a question on this conference. Professor, my question is to do with civil unrest and governments. One thing that has, to me, become apparent since COVID is governments, it's been talked about quite a bit about governments putting in emergency measures, but a lot of the emergency measures that seem to be put in place are things that governments previously have said that they can't do. Like in Ireland, for example, there was emergency measures to stop evictions during the first wave of COVID. The government took over private hospitals because there wasn't enough space, ICU space in public hospitals. But previously, with waiting lists, people asked governments, could they take over private hospitals? They said no, they didn't have the authority. Likewise, with evictions, they said no, that has nothing to do with us. It's unfortunate, but we can't do it. And then there's the case of advisors who are helping formulate policy, and then politicians who are involved in the formulation and implementation of policies are going against their own advice, but getting away with it. And then the public are being threatened with fines of X, Y, and Z if they break the guidelines. So I'm just wondering personally if a lot of the civil unrest is because there's no trust in governments anymore. They're saying one thing, they're doing another thing, and there's no consistency, and there's kind of in some ways no honesty.
Thanks for your question and reflections, Colette. I do agree with a lot of what you said in terms of that inconsistency and how that then connects to lack of trust. And, you know, I think that's where the role of social movements has become even more crucial, that there has been so much false information, inaccurate information that's been disseminated. And social movements that, you know, I think it's always been the work of social movements to sort of counteract false government information or propaganda with their own information, but that's been especially important now is really a life or death matter. And so the movement I mentioned in Nepal that's created this open platform, a lot of that was for that very reason, that their impression was that the Nepali government was instituting laws and policies and measures that, you know, they previously had said they would not implement, or that, as, you know, some of the criteria that Juan set out, for example, that would be considered very problematic from a human rights perspective. And so I think the role of social movements is in both bringing that to light and holding governments accountable, and also providing that correct counter information as a way to really repudiate the disinformation has been crucial. I'll also just make a point actually on the other end of that, in the sense of, you know, governments doing things that they previously said they wouldn't do or couldn't do, that we've also seen some positive examples of that, in the sense that, you know, governments that previously said that they could not, for example, ensure certain economic, social, and cultural rights, that we've seen, and Duke as our clinic has started to track some of these more positive and progressive measures, that governments are actually instituting some human rights, more forward-looking measures to protect, even if temporarily, people's housing, to prevent them from being evicted, or putting moratoriums on rent. We've seen in some countries, municipalities providing free internet so that school children who come from families who otherwise would have to pay for internet don't have to. That's allowing them to continue their education. We've seen different innovations with respect to civil and political rights as well. Just as voting has been, you know, restricted in some areas, also advancements with respect to that elsewhere. So I think that we can also, you know, the importance of also tracking it when it goes in the other direction, that governments previously saying, oh, we can't ensure these rights, and now under an emergency doing that, and that we need to make sure that even post-pandemic, that they don't then go backwards, which would be contrary to their obligation of continuous and progressive realization of these rights.
Thank you very much.
Thanks, Colette. Thank you so much, Aya, and particularly for providing such a positive note at this difficult time for everyone. So we have Jana Khalil on the line, who's an undergraduate law student in Maynooth University. And Jana has a question for Alicia, and then we'll come on to all of the final questions, which bring us back to Professor Helfer's paper and Amina's response. So would you like to go ahead, Jana?
I hope you can hear me. Thank you, Donna. And just a quick thank you to all of the panelists today for providing very amazing insight on such topical issues, particularly Professor Yamin. I really found interesting what you said about the crumbling of the public health mantra, particularly in socially disadvantaged locations. So my question is regarding the prioritization of health versus the economy. So when we go into historical comparison, society has faced a plethora of pandemics in the past, such as the Black Death or the Spanish flu. And before the current modern age, notwithstanding any precautions that may have been taken at the time, there was always this kind of Darwinistic approach to these fatalities that whoever can survive will, and the economy just keeps moving on. However, currently with the new technology, as well as this arise of international protections and rights, there's a prioritization on health and the restoration of the importance of health with the lockdown as an example. So, but despite all of this, especially with economies dwindling now because of the lockdowns, we're kind of reapproaching this new phase of re-establishing an importance on the economy, with some countries even in the global southern region not even having a tracing method for COVID-19. So kind of given today's advanced benefits and much more widespread knowledge on such issues, do you think governments should refocus on health restoration even at the expense of the economy and its long-term costs? And if so, to what extent or limit should there be such compromises?
So that's a really complicated question, and thank you for asking it. I'll give a stab. I'm not sure I accept the premise of a dichotomy between economy and health. I think, so on the one hand, I think that it is true that you have to get the virus under control before you are able to fully open and sustainably keep open your economy. And we've seen that in you know, our food supply chains. We've seen that in schools in different countries around the world. So that's, I think, is true. I think in countries that have more leeway, because they have more social protection, they have, people can take time off, people's health benefits are not tied to employment, for example. It is easier to get it under control in a moderate way. When you don't have that and you have a choice between lockdown, which can be, it can create other, I should also say, it's not just, containing COVID is not the full scope of health, right? We know that lockdowns have led to spikes in domestic violence, in mental health issues, in addictions and suicides, in delaying other care, et cetera, et cetera. So I think, one, it's probably false to say, you know, it's one or the other. It's a question of negotiation. And that's something that democracies are supposed to do. We're supposed to deal with different diverse needs and perspectives of individuals and have some ability to deliberate about meeting, you know, maybe the elderly who can't go back to work, maybe children who need, in a way that those voices are heard, that communities are engaged, that the population affected by policies is heard. And so some of these emergency measures concentrate powers in the executive branch and sideline, say, the political branches of government. Absolutely, judicial review is important, but often the ability for Congress or political organs to deliberate has been significantly reduced, sometimes deliberately and sometimes almost by default. But that's the point. I mean, I don't think there is any one size fits all answer, because the one size fits all is the colonialist answer.
Thank you so much, Alicia. That was wonderful. And Jana, thank you. A very complex question, and thanks for researching that and looking into it for us. It's fantastic. So coming back then to the original presentations at the beginning around human rights derogations and international human rights treaties. We have a question from Desiree here, just saying thank you, and that Professor Helfer's paper sounds absolutely fascinating, and she looks forward to your response concerning monist versus dualist legal systems, particularly as they relate to potential disincentives to invoke derogation clauses. Presumably, monist systems will not share concerns over domestic litigation, Desiree says, and looking forward to your proposals concerning the translation of human rights treaties into national legislation. And then Harshit Rai is also here and has a question for Professor Amina Adanan. So Harshit notes that if we think about derogations as necessary means to regulate the extent or proportion to which states may derogate from human rights, do you think that the disparity in the derogation regime concerning civil and political rights as opposed to social and economic rights in some ways reinforces the dominant interests of the global north in safeguarding civil and political rights, as opposed to economic and social rights, which were more critical for the global south? So a lot in all of that, and I know that you might like to come back to other points that were raised by other panelists. So taking whatever you like from those comments and questions. Would you like to come in maybe first, Laurence?
Sure. I'm having trouble.
That might be a fault on our end. I can see that you're muted. Is it difficult to unmute? Right, that might be something that we've done. Let me just double check here. I'm unmuting you here, so hopefully that will do the trick. Yeah, you should be audible now.
Can you hear me?
Yeah.
Yes?
Yeah.
Okay, because I still show up as unmuted, sorry.
Okay, sorry about that.
No worries, you can hear me, yes? Okay, good. First, I guess I would like to clarify one point in response to, I'll try to bring all the comments together, but my responses to all the comments together. So obviously thanks first to Amina for engaging so closely in the paper. I want to start, and maybe this will link to some of the other comments, by referring to something Professor Mendes said, just to clarify that I want to stress the distinction between states of emergency and emergency legislation and derogation. So I'm not at all an advocate for states declaring emergencies or applying extraordinary powers informally, but I think it's inevitable that they will do so and try to do so, and in doing that will restrict rights. And then the question is how to constrain their abuse, right? Which rights should governments restrict? Or is there limits on that? What are the reasonableness of the restrictions? We were talking about that, and how long the restrictions last. And so I see the international system of derogations as acting a constraint on governments in two dimensions. And this will then lead me back into the comments that Amina and others were raising. And that is internationally, and domestically, that's one dimension, and through formal review mechanisms, and informally through political pressure and social movements along the lines of what I was saying earlier. So the international and domestic mechanisms, right? We've talked a lot about the way in which international review works, or is supposed to work, or doesn't work as well as it could. And it's true that when I speak about domestic mechanisms, and I think, and Amina was really thinking along these lines, that there would be some concern, and Desiree was raising this as well, some concern about whether there would actually be a domestic review mechanism available in countries that have not domesticated the human rights agreements. And so my point is somewhat broader than that. So certainly in some countries, so in Europe, you do have that domestication, and you do have it in many countries in Latin America through direct effect and incorporation through legislation. But the point is broader. So that when governments is opposed to being surreptitious in their violations, the international mechanism provides a kind of template against which actors can judge government responses and restrictions during times of emergency, both through formal legal mechanisms and informally as well. So even in countries where domestic legal system, where treaties are not automatically domesticated, the fact that one has the government on record as saying, these are the rights we will restrict for this reason, for this period of time. That's what a derogation enables you to do, to get that on the record. That can be used through, social mobilization, through political pressure, as well as through formal legal mechanisms. So I think that's the key kind of point that I want to emphasize and stress, that this is not just, kind of formal legal institutions. It's in part getting governments to come out of the shadows and to justify what they're doing. And then that leads back, finally, Donna, into your point by that, and then one more for Amina that I want to raise. So Donna, you make the very important point, and this is really, it still needs to be explored more, the difference between derogations and other ordinary limitations and exceptions to rights. The way I read the case law, and I think this comes directly from the text of all of the derogation clauses and suspension clauses, is the language strictly required by the exigency of the situation does import a proportionality and necessity and a reasonableness analysis. I think that's the better view. if you accept that, then the question becomes, well, what's really the distinction then between an exception and a derogation if they're both subject to very similar tests? Well, the answer to that question is kind of complicated, but first I would say for some rights, it's not clear we have that. So where derogation has the most obvious application are in things relating to detentions, where we don't have the same treaty-based clawback clauses, as Rosalind Higgins referred to them. And so where the tests are really quite different. So we see that in some of the ECHR case law, where you have the court upholding, finding a violation of a detention prior to a derogation in the situation between Ireland and the UK, and then after the derogation saying it's okay. But that's an unusual example. And in fact, one of the reasons why states may not have derogated, as I explained toward the end of the paper, is because they may have thought that ordinary exceptions and limitations were sufficient to handle their limitations in order to combat the coronavirus. And I guess my response to that is to say, I can accept that as being plausible, but I think none of those ordinary limitations on rights, whether they're done de jure or de facto, require the kind of notice and justification through a formal mechanism, putting governments on the record, so to speak, both internationally and domestically, that derogations require. And that's really the value that derogations add. Now, having said all that, I want to conclude by the final point that Amina made about going back to the drafting history, the travaux. And I thought that was that's a very insightful point, and it's a true point, right? I cite to Brian Simpson about the British reason for putting in these derogation clauses, no doubt linked to colonialism, and that's absolutely true. Less clear how you deal with the American situation. I think that's more a question of kind of copying an institutional framework and bringing over something with it. And I noticed that, it didn't specifically reference the inter-American system, but the point is well taken. And I think, like so much of international human rights law, what has happened is the treaty bodies, the tribunals, civil society have taken a mechanism that had as its origins a kind of colonial, not post-colonial even, a kind of justification, and turned it into a much broader way for constraining rights during emergencies. And it's that more modern understanding that I think is the one that everyone is working with here, and that I'm hoping to suggest some improvements to with the reforms that I identify in the back half of the paper. I'll stop there.
That's fantastic. Thank you so much, Professor Helfer. Amina, would you like to come in on any of the points that were raised?
Yeah, absolutely. Thanks very much to Professor Helfer for the response to the response. So your point about how international mechanisms should ideally be there to review derogations of states, I completely agree with that. And I know in your paper you do identify that that is somewhat problematic due to the slow pace of work of human rights institutions and the need to exhaust domestic remedies first. So with that in mind, I do fully agree that international mechanisms are best placed to review international human rights treaties and their content, be they derogations or not. But because of the problems with procedures and access to those mechanisms as well, that does pose problems for those seeking to challenge their state's human rights derogations. That leads me to a point/question that I had based on some of the presentations today in relation to social movements. And I know this was the role of social movements in international human rights law was specifically addressed by a number of the professors today. But just listening to those presentations, I was thinking, what is there place for social? Is there a place for more of an increased presence of social movements within the international human rights infrastructure? Obviously, you know, you look at some of the mechanisms such as the treaty monitoring bodies, and the role of support that NGOs give to individuals who make communications to those bodies. But outside of that, and outside of the review or the shadow reports that that civil society groups can give to in the context of states having their human rights record reviewed in the likes of the UPR, or when they're going through their state reviews in the respective treaty bodies. I do wonder, should there be more of a role for social movements in the infrastructure that grants human rights within the universal system? Because if we look to the mobilization of civil society in the context of, you know, Black Lives Matter, or protests against COVID restrictions and so forth, there is more of a need, certainly in society, or more of a desire that there is more of a bottom-up approach to human rights, as opposed to state-controlled and top-down infrastructure that is the basis of the international human rights regime. So I just wonder, is there, with that in mind, like, can the role of social movements in the international human rights system be improved? So that's something to just to consider. Not just to Professor Helfer, but perhaps to some of the other speakers, Professor Yamin and Professor Tut and Professor Fujimura Francolo. So that's just to go back on that point. I know you commented that I didn't explore the the historical treaty negotiations of the American Convention on Human Rights, and that was purely due to time constraints. Something I would love to explore in more detail, just to see if there is that similarity in terms of you know, dominant states who created that convention, and to see if it was a case of just importing the provisions of the ECHR and the ICCPR, which I suspect it might be, but again, that would have to be proven with data. So thanks very much.
That's excellent. Thank you so much, Amina. Would anyone else like to come in on any of those points or questions that were raised? We are. We're close enough to the time, but there's plenty of food for thought in all of that, and hopefully we can all come back together at some point to discuss these issues, because they're so current, contemporary, so important. And I'm so grateful to all of the experts on here who provided insights and really, really important angles, critiques on the various issues arising. I'd also like to thank the Law School again, to Trinity Research in the Social Sciences as well, including Meg McGrath and Donna Lyons. Thank you so much to the students who got involved. Thanks to the attendees and for all of your questions. In particular, again, thank you so much to the panelists. It's been a great honour and a privilege to have you at Trinity College Dublin, and to get these fantastic insights into your various fields.
Thank you, Donna.
Yeah, thank you so much. And I'll close the session there. Thank you.
Okay.
Thank you.
Take care.
Thank you.